Yeah, because first of all, I mentioned two items for listing on Thursday last week.
New items.
Two items.
New.
Right.
New items or old?
So that's it. Regarding payment of contractor fee, which is pending.
Friday. No, Thursday. You want it when? When do you want? Wednesday.
Yes, that's it. Okay. May please do that. The Lordship, I'd like to mention item number 18 and 19 for today's delivery.
Yes.
Lordship, the instructions are still awaited. We have taken consent to the other side regarding matter. Maybe after after 10 days, Lordship. We'll look in our
Who's for the prediction?
Okay. What is the date? Maybe.
Mr.
I am here.
M. Bhuya, appearing for the PWD. Praise for how much time?
10 days, sir.
Praise for 2 weeks time to obtain instructions and file affidavit. The same is not objected to by Mr. Hamdar. This is the matter. See what it is. Order to.
What? But I'm praying for listing of content case. Decided. Wait, item number 17, wait. 17. This is the time we filed until now. Might, at the time of filing, till now, a lot of changes might have happened. You need to clarify them. Can I have
What? No, what clarification do you need?
because at the time we said when the survey was being made, there were some opinions given that these fisheries need to be closed. And those fisheries, when they were closed, they were arbitrary auction was going on. Presently, my colleague on the other side who's appearing also had a word that some might have been closed, some might have been given for settlement also. So we do not know. Both of us will clarify that. Can I have it after 2 weeks? There's no intent. It will be proper.
2019 matter.
Well, the issue is different, but since the developments might have taken place, it will be proper for me to address the honorable. Nothing more.
This is not a PIL or
It's not a PIL.
Then
This
what
is
is it?
because
What right of yours has been violated?
my lordship, but I'll place it here. Can I have it in 2 weeks' time?
It has been adjourned 7 again.
No, only once. Or 7 days, lordship.
It's there one pays for time to obtain instructions. This is the matter. Give a date. No further adjournment.
No,
will be given on the next.
Sorry.
Next digital. Addiction number 14 madam. 1 4 motion method.
Item
14.
14 yes.
While the English council Mr. Y.S. Mannan is unavailable on that. Next Monday, my left time. Next Monday maybe.
Has it been cancelled? Has your paper shop been cancelled?
My lord, actually I am not the council, my lord. On behalf of Y.S. Mannan.
Where is he? Where is he?
Today he is not available. Madam.
He is available in some other court.
No, madam. It's no personal difficulty, madam.
There are the prayer for adjournment made on behalf of Mr. Y.S. Manan. This is the matter after the week. So stop. The counsel for the petitioner shall inform this court as to whether the fair price shop license, which was suspended on April 2023, has been cancelled by the state authority. Who is appearing for the state? Okay. What has happened? Has the license been cancelled?
I have their inspection. I don't know. They'll give you exam matter.
Actually, it has come today for what? Actually, it's a
Muslim.
motion.
Muslim. Oh, Chocos, Chocos nothing is issue. Okay. Chocos is issue to cancel.
I know, just find out, huh? Try to meet that.
Yes.
So, Mr. M. Chandra shall complete instructions as to whether the fair price shop license has been cancelled. And whether the inquiry report was given to the petition. Inquiry report dated 21/3/24 was given to the petition. Place the matter when after the week. After, huh? It's the matter after the week. All right.
May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 33
You're for whom?
for RM Das, petitioner.
So you're asking, who's asking for adjournment?
Lordship, please. from the petitioner's side.
Madam, it has been adjourned time and again from your
Lordship,
six times in a row it has been adjourned.
some documents are awaited.
Huh?
Some documents are awaited.
Nothing is awaited. The only thing is whether leave encashment is, you are eligible to receive leave encashment. That's all. Other things have all been given to you. You're not entitled to GIS. Only thing is whether leave encashment can be given to you. That's all. And we have been adjourning this case only on that issue for the last 6 days.
Lordship, last.
Madam, this is a 2019 matter, 2020 matter, 1920. What are you going to, what instructions are you going to take?
Lordship, some documents are awaited from,
Documents regarding what?
I'm not aware of.
Where is Mr. Arimdar? He is in some other court.
Yes, Lord.
Tell him to come.
Okay.
Wait, please. What you were back to mention item number 27.
Yes. Yes, what about it?
Okay, can you please keep on making it?
No, why? What difficulty? Yes, what happened now? Has the mining rights been given to some other person or what?
Lordship, there is an intent that we won't proceed with mining of that area.
That's what, there's an interim order.
Undertaking given by the forest official.
That's what.
Or it won't be leased out to any other person.
Correct, but then you cannot hide behind that order and just leave it.
Lordship, today it also have been a joint prayer, but a date may be fixed for 28th of this month, Lordship.
Okay, right. On the prayer of the parties, the matter is adjourned. For how much?
26.
Till 26. Huh?
20 June,
20 June.
20 June.
20 June 2024. The matter pertains to the letter of intent given to the petitioner being cancelled pursuant to the NIT dated 11/11/2021 on the ground that environmental clearance certificate has not been submitted by the petitioner.
Lordship, the interim undertaking.
I do not know whether I should allow 2021 NIT.
Till the next day, Lordship.
It is in order to consider till the next thing.
Lordship, the next day is 20 June.
20 June 20.
Yes.
20. Till the matter of 20.
May please, Lordship. Lordship,
Mr.
this matter I want to withdraw my
What is your name?
RI Bhuya.
R
RI Bhuya.
R.I.
Correct.
Your name is not here. Where is the
On behalf of B. Sinha, my lord.
Mr. R.I. Bhuya?
Yes, my lord.
Appearing on behalf of Mr. P. Sinha, learned counsel for the petition. Says that he may be allowed to withdraw the district upon it. Received from the petition. Ms. M.D. Pola appears for the transport department.
Call the response. The fitness certificate has already been issued.
The prayer of the petition counsel is allowed. This petition is dismissed.
Deep your place.
Like in 2-4.
Lordship,
Okay, right, Mr. L.R. Mazumdar, learned counsel for the petition, I must submit that the order dated 15/3/24 passed at WPC 1489/24 requiring the respondent to dispose of the field of the petitioners has not been complied with till date. Issue notice returnable in 4 weeks, petitioner to take steps for service of notice upon the respondent, registered post KG within 3 days. This is the matter of the court.
all right.
Heard Mr. J. Sharma, learned counsel for the petition of subject that the order dated 29/1/24 passed with WCC 4269/23 requiring the respondent to dispose of the petitioner's representation dated 19/6/23 has not been considered. So, step within 2 days. 3 days, sorry. Step within. First with the that M.Z. Shah, counsel for the petition of the topic that the order dated 16/8/23 passed in WPC 6733 of 22, requiring the respondent to pay the petitioner rupees 7,51,110. Has not been done. Do not accept. Right.
My lord, I think my learned friend was supposed to have been, but
Yes,
Jyoti is not being. During the last month, during the last month of, last week of this month, Jyoti will. Huh? Jyoti will head on the last week of this month. So lordship, there is a date to know that you can get what you think. Then also, Jyoti. It's a paper. So there is an instruction given to him, but they have reduced the demand.
but the BOT has to approve that. That is,
Cannot take in the,
know.
my power is.
that
35%.
reassessment has been made.
Yeah.
Only thing that
There is
approval.
only one point, since my learned friend will be taking the instruction based on the BOD. The people also to kindly have the instruction which my learned friend placed the other day. The letter addressed to him where that reassessment was done. Second phase of that.
Yes.
Kindly see, my lord, the total area is 40 hectares and operational area is 35 hectares.
Ah.
So therefore, my lord, the revenue has to be assessed based on operational area. On that also let them have the instruction. I think they are having the instruction. Because operational area makes no, total area makes no sense if I can't operate. Because if it is 5 hectare less also, then I'll get substantial relief in terms of revenue. That means all that we are saying also is correct. Let them have the decision on that also.
Okay, right. Mr. P. Sharma, the learned counsel for the AFDC, submits that the board of directors will be sitting at the end of June 2024. With respect to, with respect to the assessment of revenue made, reassessment of revenue made by the AFDC in respect of 23, 24 and 57 number Kilochi field situated under Bakbar Revenue Service. Wherein the petitioner apparently suffered huge loss due to the COVID-19 pandemic, flood, erosion, etc. The petitioner's counsel submits that in terms of the letter dated 20/03/2024 issued by the managing director AFDC to the standing council AFDC and the annexure therein, might be seen that the total area of the field is 40.00 hectares, while the operational area is 35.00 hectares. Submit that a decision may be taken by the respondent authority with regard to whether the reassessment or in terms of the entire 40 hectare area or the operational area of 35.00.
So, it is all based on operational total area.
Ah.
Because it is shown towards the below.
Let him clarify. Good stuff. It's the event, the assessment is made only upon, only on the total area. Comma. The respondent may also take a decision as to whether a reassessment can be done on the operational area only. If this is the matter in July, but after
First week of, after.
first in July is the holiday. After the, this is the matter after the week.
Our lease is up to 31st of March next year. Then, okay, but
No, but that way you can continue working.
our actual term is up to 31st of March 25. So this whole year has gone. Anyway, let it come. There's no. Or if my learned friend says, can we have in the last part of June?
We can do that also.
Yes, my lord, before vacation.
This is the matter on 20, but again, that's all Muslim day.
No, sir. Let us take a time. Maybe
This is
may
the
not be on
matter
the
of-
last day,
This is the matter on
26th or 27th.
27,
Oh.
27 too. Not-
We fall into that category of fishery, which was the daily basis and the orders of the court. And the government had also realized that an issue in order, saying that those category of fisheries which were allowed to run on daily basis on orders of the court did not be touched now. And my lord, order of 29, the detailed order, my lord, only the instruction part was when would you float the tender? Because 4 years back, you were directed to do so, 19. But my consideration of tender was also there.
But it is, tender has to be floated by deputy commissioner. Yes. I don't have any instruction whether tender was floated or not.
No,
No, so who is the query for the deputy commissioner? You see, because once we allow his prayer, then it's going to be a flood of.
So Lordship may give some time, I will obtain instruction.
When can you finish? By this week, Friday?
Friday,
Friday.
I will try on Monday.
You obtain instruction.
but if I may apprise my lord for one thing, with all humility,
Otherwise, it is done as per on, I will put for that.
absolutely, with all humility, the order dated 18/5/2024 is contrary to their own decision, which I placed on 9th of May 24. Some error might have crept in with it. That's okay, barely okay. Because 9th of May 24 says they have taken a decision not to touch those fisheries which are operating under the orders of the court.
That is which
We have placed the order, the lordship had taken note of that the other day. 9th of May, it's there record. Even my
9th of May or April?
9th of, 4th of April. Correct.
Fourth May.
4th May, 4th May. 4th, I'm sorry. 4th May.
4th May.
4th May. So this order they have taken.
You see, as per this 4th May order, those fisheries which are running on the basis of court orders on daily basis, they stand on a different foot. That is the fault.
That part fishery department should clarify. Otherwise, that part fishery department should clarify. That part. Otherwise, if you can, and we have act upon the fishery department notification. We have act upon as per fishery department notification. Regarding court order, which fisheries are operating on the basis of the court order, that part they have to clarify. Whether they have taken any steps for or modification or not, that part they have to clarify.
No, it's an order.
Something is order. You can't talk to one of the officers or commissioners.
But it will not known to the officers. No, here produces where is that?
My lordship. 4th of May is with me.
Page?
4th of May,
No, it's not in the writ petition.
No, we have placed it, my lord, on the first day.
No, but it's not part of the writ petition.
It could not, we didn't have the order on the first day. We placed
2019
No, did you have
No,
you
no,
given
I
the
don't, no, I'm saying about 2019 order, Lordship. That is the reason 9th May order, 4th May order was passed. Lordship.
Correct.
Correct. Sometimes, Lordship, something maybe missed by the officer, we saw.
They might have missed,
Might have
possible, might have missed, possible.
Might.
So why don't you take a decision?
So we have to come
Till
for
29.
no, lordship.
This is by the secretary, commission secretary, fishery department.
Fishery department.
Then,
But we came to know we have taken a decision. Actually, our officers are not involved. So we take decision regarding this part. If we are
why do you think the last time we had adjourned this matter?
not
For you to obtain instructions, I think we'll call them here. Clarify.
for experience of tender also, the approval from the parent teacher department.
Absolutely.
We
Government
have
is
given
needed.
the approval, then DC can issue them. Monday's time, lordship, I will clarify.
Why Monday's time? I gave you last time also, last week also.
So tender also, we have no rule.
Today is what date? Today is last week. Since
Okay, give 1 day, lord, tomorrow. 1 day, lord, only 1 day.
Matlab, so far the interim,
let him update.
but he is obtaining instruction only on the part when they would issue the tender.
No,
I'm not on that.
let everything be clear. You bring this, you take instructions on this.
Tomorrow,
You see, because
nothing.
that order is for no more daily fishing, no more daily settlement. Thereafter, you have passed a subsequent order on 4th May, saying that for those fisheries which has been allowed to be settled on daily basis, till NIT is issued, you have said that that order should not cover it.
But it will be contempt, lord, it will be against court order, lord. If we go that order, lord, it will be against.
Correct, that's why. That is what. So that is why it is order for allowing you to have a NIT issued was made in the year 2019.
That's it.
What have you been doing for the last 5 years?
That's it. That.
Why shouldn't the officers come here? Not virtual, present, all of them, secretary included. Why shouldn't they come here and clarify?
Some message on the part of the. That's why I put whatever.
Huh?
Because there is an earlier order for tendering settlement of the fishery for the tender. It was not done by the authority.
That is why.
That's why option 942.
No, but then there is a subsequent notification issued by
There is a conflict. No, there is a regarding daily basis. There is a wrong interpretation on the. There is now the past is for lordship. I already submitted before your lordship. That regarding now, everything is going to be transparent lordship. This part I will clarify lordship.
when?
Day after tomorrow lordship. Give me 1 day time.
Okay, this is the matter.
The consideration.
The Mr. P. Sharma, learned counsel for the AFDC, and Mr. K. Roy appearing for the huh?
Not AFDC.
for Fishery Department, and Mr. K. Roy, learned counsel for the Deputy Commissioner, District Commissioner, shall obtain definite instructions as to why NIT has not been issued despite the order for the same having been made on 24/12/2019 in WPC 8467/2009.
My lord, can
This
you
is the matter with it.
observe about the interim part, consideration?
Interim order may be considered on the next.
Yeah, please, the lordship kindly pass over the matter at two.
Huh?
At two, pass over the matter
At 2.
at
I think it should be. It's okay. What to do, madam? They, have you, I hope the funds are being provided by the center, because there's so many matters.
Order has already.
Miss Chaudhary, maybe in this case, huh? Because the stand of the government will be the same. That-
Strong back, but. Earlier fund.
Was the full amount paid? Have you got the earlier affidavit from the government? affidavit where they have said that this much has been to be paid, this much has to be paid by such.
Yes, Lordship, I have to.
Can you bring the affidavit?
Yes,
Yeah, bring that affidavit, then we'll ask her to clarify. Otherwise, what is going to happen? Is we are saying do this, do this, do this. Then you'll have, probably when you file contempt, when it does, then what will happen is again that issue of how much funds has been given.
so obtain instruction, a week time may be given, Lordship.
Only thing is, of course, it's a covered matter. That is.
Yes,
On the other hand, it's a covered matter by the. How will we suppose it apply that? It's a covered matter by the other. So this matter is 2820. This is again Moregaon.
Lordship, this is for
Everything is Moregaon. Which page?
page 16,
The scheme is the same.
same Lordship.
And how
Liability.
much is the amount payable?
That is page 18, Lordship.
Huh?
Page 18, 9,17,902.
9,17,902.
Thousand.
Okay. This was yes, yes, to do that because it's in those utility structures because whether how much have you paid?
Yes.
How much is the whether you have paid in full or not?
Okay.
You have completed the contract.
Mother,
There's completion of contract.
completed long back, mother.
When?
Now, I've completed on 8/9/2023.
Why you have to come in this spot straight away?
No, there is an internal mother, remedy, my lord. We approached the grievance registration committee 17 months back. They're not doing it. Division bench passed an order, my lord. Division bench passed an order that the DRC does not take decision seats over the matter, my lord. that is no more than execution remedy, my lord. 17 months, they are given two reminder, my lord.
17 months? How can it be 17 months? You completed your work in
No,
23
no.
September.
No, my lord, when they started deducting, my lord, immediately, my lord, you kindly see page 76. Immediately, I went to
Right.
here, see.
Heard Mr.
Please, Chakrabarti.
B. Chakrabarti, Learned Counsel for the petition of submit that that the respondent should be directed to refund the principal security deposit of rupees 48,95,000 with interest at the rate of 18% per annum, along with the additional security deposit of rupees 1,21,06,030 with interest at the rate of 18%, with effect from September 2020. He submits that the deduction made by the respondent, deduction from where?
Additional deduction, there, deduction from my running bill.
The deduction made by the respondent from the running bill of the petition has been put to challenge before the
GST, my lord, Grievance Redressal Committee.
before the district redressal committee, grievance redressal committee on
On 31/1/2023.
on
And
31
then
1
two reminders.
2023. However, as nothing has been forthcoming from the GRC, the petitioner has approached it. Issue notice returnable in 4 weeks, Mr. H. Gupta accept notice on behalf of all the response.
On including, my lord, I have a submission, my lord. Here, FCI has no objection in refunding me the principal sum. Only interest is, they are saying that interest they will not pay. This is the only issue in this situation, my lord. Whether they are liable to pay interest or
Let
that.
them say,
Now, only thing is that, my lord, it will be in the interest of FCI if they clear this, my lord, if I succeed.
Mr. Council, let them decide
My lord.
first.
But then, notice may go on interim prayer, my lord, or maybe an observation, my lord, there may not be any bar, my lord.
Interim prayer is the final prayer.
Correct. How can you?
No, final prayer is
This is a
interest,
matter
my
of
lord.
the operating. If you notice returnable in 4 weeks, Mr. H. Gupta accept notice on behalf of all the respondents, all the.
But, date is given.
Next.
My lord, in this case, my lord, the non-payment of contractual bills.
I had heard Mr. Edin Deingia, Learned Counsel for the petitioner, to submit that the contractual dues of the petitioner amounting to rupees 4,82,214 has not been paid. Ms. A. Loda accept notice on behalf of the. What is this? Is it a admitted amount or what?
My lord, admitted amount, my lord, what happened, my lord?
It's not Jal Shakti.
No, Lordship. Lordship, this is an SDRF scheme, State Disaster Relief
Oh,
Fund.
my lord, FCR, last payment is here.
Yeah, okay, the SDRF. So Lordship, in this case, Deputy Commissioner and the revenue is the necessary party. As they are
My
the
lord, kindly
competent
see, my lord,
authority
for a moment, my
to
lord,
make the payment.
Huh?
As they are the competent authority to make the payment,
The TCM?
the revenue.
my lord, kindly see page 53. my
Mr. Counsel, I cannot dispose of the writ
Lord,
petition straight away.
lord.
Now you see, he has been kind enough to say who are the necessary parties. In their affidavit, what she said now she's going to say there. So it depends upon you, you want to do something with your writ petition or not. According to me, that's the stand they're going to take in the affidavit. That DC is the one who is to pay, not them. So either you implead them straight away or you want to file a application for impleadment, I don't know, whatever you want to. You take a decision. Otherwise,
My lord, please,
accept this is on behalf of respondents number.
All the respondents, 1, 2, and 3.
He submit that even if the amount claimed by the petitioner is an admitted amount, the authority to pay the same would be the district commissioner, concerned district commissioner, along with
Revenue.
the revenue department, along with the revenue branch or revenue department, along with the revenue branch. I just say, huh? The revenue branch of the deputy commissioner's office. correct?
Secretary, my lord. I think, my lord.
Yeah, it is secretary. Yeah.
And the revenue and disaster management. However, the same are not parties in the. Easier for you to withdraw and file a fresh. That's your prerogative. This is the matter of the phone.
Apply.
Apply to.
Right, Mr. Here we say, counter for yes, anything? Let transfer for the particular subject that the particular contractual dues amounting to rupees 59,09, 400 has not been paid. To notice to all the, make to notice to the response, Senator for which it's the RK, sorry, Mutahari accept notice on behalf of all the respondents. This is a matter of. To enable the response to find applicant. Public.
Case lordship petitioner is a single health bidder for grant of biometric license lordship in a rural area. It's not the proposed area is in a rural area. But the authority has rejected his bid comparing the bid offered for urban areas. That decision is irrational, right? So in view of the lordship. It can be.
Lordship, first of all, there's an amendment in the rule, your lordship. Which non it says that if the authority is satisfied with a certain single tender, and it's a question of revenue, your lordship, first and foremost.
No, that 114 rule does not say so.
Just a minute, just let him continue, let him finish.
I mean,
Huh?
to amend it with the function.
And this one is also violation of this rule. I mean,
Which is 114, your lordship.
Huh?
114.
114 A1 from 114.
Rule 40, your lordship. Where there's only one tender for a shop, the licensing authority satisfied that tender is eligible for grant of license and that the statutory requirement has been fulfilled by the has been fulfilled. He shall accept the initial grant bid offered by the applicant and may grant a license with previous approval of state government after realizing the applicable license fees and security deposit. Provided that if he is not satisfied, he may reject the application after recording the reasons thereof. So here, the petitioner is stating that urban and rural, but the rule doesn't say whether it is urban or rural or not. In fact, a similar matter came up before your lordship. Lordship passes order your lordship. But even this matter is similar to the work.
If the comparison is made in change.
There are 19 about. On considering the facts that the additional state respondent to retender the IMFL detail of license has been made only with the object for the government to earn higher revenue, taking in view the fact that the bids submitted for the other locations were much higher. It is quoted of the state decision made by the respondents cannot be said to be arbitrary or unreasonable. The government being the protector guardian of the government revenue finance, reason for retendering due to the low bid amount of the petitioner when compared with the bids given for other location shows that the government decision is not to accept the petitioner's bid is not in conflict with Rule 114 of 2023 amendment. The opinion of the government to go for a retender is not for an extraordinary reason, but with the object of earning more revenue for the state, which is in public interest. Besides, when considering present issue in terms of the law laid down Supreme Court and the High Court, the right to refuse a bid offer is always available to the government, provided the same is not arbitrary. In the present case, decision to retender is not found to be arbitrary or unreasonable, though the petitioner bid may have been above the minimum bid price fixed by the government, your lordship. Even if the authority wants to go for a retender, he can always participate in a retender, your lordship.
But lordship, in this case, lordship, the comparison is made in the municipal area. Both the shop is for municipality area, lord. But in my case, lordship, my proposed shop is in lordship rural area in under Gaon Panchayat. When the lordship, the license fees is different. Like
What was the bid of the, for that, this urban
urban
area?
area.
Urban
For that urban 36 lakh charging lordship, that is urban area,
and
and municipal area. Whereas my bid is around lordship, 2 lakh 50, is in Gaon Panchayat area. Lord.
Yeah, how much is your bid? 2 lakh?
2 lakh.
And in the urban area it was 36 lakh.
36.
Urban area 36 lakh.
And for you, 2 lakh.
No, more than 2 lakh 30 load.
2 lakh 30 is your bid.
Lot.
So what is wrong?
Lordship. As per the rule, as per the NIP lordship.
So who should think, whose decision should be considered as to whether a rate is reasonable or not? Should it be yours? Should your reasoning?
That comparison should be made for offered in a rural area, Lord. Even
But
the license-
supposing,
Lord,
but supposing,
the license, fees also.
no, but supposing there is nothing to compare it with, then have you
Then they have
compared?
to-
Have you compared it with any other rural license?
Then they have to give a lot.
No, you have to give a decision also. It's not that you give your problem and say you solve it. You have got to solve your own problem. The urban area license has been given at the rate of 36 lakh,
Yes, sir.
and your license, your bid is for 2 lakh 30,000.
Huge difference, sir.
What is wrong?
Even the
Can't they take a decision?
also, appreciate lordship, the license fees also different for rural area and urban area.
What is the difference between urban area and those?
For
Rural area?
urban area is 2 lakh lordship, and for rural area is 1 lakh.
1 lakh. So if you use that same analogy, 2 lakh, 1 lakh, 50%. 2.3 lakhs and 36 lakh analogy is how much?
In
Less
that
than-
area, lordship,
Less than around, it's around 5%. How can it be?
the one shop in rural area, lordship, the economic activity of the shop also to be considered, lordship.
So that has to be decided by whom? Can it be decided by you? That the viability range will be this much?
My submission is that decision is irrational because they have to make a decision comparing economic condition of the.
Very, huh?
Yes, compared it, even in fact, not only his, there are 3 more white shops also, tender is located. You go for in tender, your lordship. It's in the minus also.
That
Show
all
me,
in
show me where.
municipality area law.
At pay 75, your lordship. Not only him, your lordship. There are 2 more.
Others are all in municipality area. With that of the.
Yours is not in a municipality, yours is in a
I'm in
rural
the
area.
town panchayat area law, in the rural area. That's why lordship that decision is irrational, my friend.
Department, excise department, or welfare department, revenue department. We want revenue, we consider business there. He can always come and join for return, your lordship. We're not barring him to come and join.
And even lordship, lordship 114A, one of the 114, lordship, the provider lordship, he says that if he is not satisfied, the satisfaction is regarding eligibility of the petitioner. The petitioner is eligible, technically qualified and eligible on all aspect lordship. So in view of this provision also, they are supposed to give lordship the first part lordship, where there is only one tender for the shop, if the licensee would be satisfied, the tender is eligible. There is lordship petitioner is eligible for grant of license that the statutory requirement have been fulfilled. He shall accept the initial bid offered by the applicant and may grant license with the previous approval of the state government after realizing the applicable license fees and security deposit. Provided if he is not satisfied, satisfaction is regarding the eligibility law. Then lordship, they may decide otherwise or reject my application with vision order. But there is no question of my tender is not eligible, Lord. There is no finding on that part.
Well,
I'm eligible, I'm qualified technically, and the technical bid, Lord, I'm qualified, I'm eligible for the license.
a bidder participating in tender cannot insist that a tender should be accepted, your lordship. Because this rule change how cannot accept simply because tender is highest or lowest, your lordship. We cannot say that my tender has to be accepted. Now the case is that since we have compared it with other locations, we have seen that his bid is low. So we are proposing for a new tender. He can participate. The main motive of department is to earn more revenue, lordship. That's it. He can come and participate.
Rule is very clear, Lord.
These cases, this 114
Yes.
does not provide for rejecting a bid on the ground of submission of a low tender. The bid amount or low bid amount. It only pertains to whether he is eligible or not? Eligible tenderer on,
Going to eligible tender, but is there provided that if he's not satisfied,
not satisfied with
not
what?
satisfied in regarding his eligibility and his tender, your lordship. And here the rule 40 in the first part says, where there's one tender per shop, if the licensing authority is satisfied that the tender is eligible for grant of license, and that the statutory requirement has been fulfilled, the shall accept the initial grant bid offered by the applicant and may grant the license to the previous approved state government after realizing the applicable license fees and security deposit. Provided that if he is not satisfied, he may reject the application after recording the
Not
results of the
satisfied would have to be considered with the previous portion. It cannot be, it's not a standalone.
a standalone. But here we have accepted everything. But since we have seen that this bid is comparatively very low as compared to the other bids, so we have decided to go for retender. It's not that we are rejecting him in anything. It's that we're going for retender. You come and you bid again. It's not that we're exposing his price to anybody.
He's the only tenderer.
He's the
Yes.
only tenderer. And the reason here is if there's only one tenderer, there is might be an apprehension of petitioner. If they goes a retender, he might have competition along. He might have.
I know, but then he's not on that. He's on this amendment, the
Amendment.
provision.
But
The provision is not covering all aspects. That's what it's saying.
he's saying, but his bid is comparatively low, your lordship. So that's why we are asking.
But where does it say in this, in 14, that if the tender amount is low, he can be rejected?
There's
Where
no
does it
question about it. There's not saying tender amount is low. But it's the authority who decides. The authority decides since the bid is low, only thing we can go to retender. We're not rejecting his bid or anything. We come and participate in retender. That's our only case. Since your bid is less compared to other bid areas, your bid is since comparatively, not only his, that too go.
Anyway, we need to notice, where you file, you bring the report. Right, Mr.
As you know.
That also for the petitioner who submit. That the petitioner's bid for IMFL of of license was rejected on the ground that his bid of rupees 2,30,000 was much less than the bid for a shop in the urban area. For a IMFL of license in a urban area, which has been allowed, which has been allowed as per the at the rate of rupees 36,11,111. Yes, sir. The petitioner of the subject that the petitioner's IMFL of license was for CAR3, CAR3, which was in a rural area, while the bid given for CAR4, urban area was for 31, 36,11,11. The petitioner's counsel submit that Rule 114 capital A of the Assam Excise Bracket Amendment Rule 2023 does not provide for the rejection of a tender only on the ground that bid amount is too low. Accordingly, the rejection of the petitioner's tender should be set. It should notice returnable in forward with the RR except notice on behalf of all the respondents.
No, it's number 1, 2, and 4.
One, two. Who is for 3?
Government.
While Mr. M. Chetty accepts notice on behalf of point number.
Okay, I'll produce the recorded document because we have posted
Is the matter on
and it takes 26 years.
how it should be? Well, 3 weeks.
Very well.
3 weeks. Yeah, we get 3 weeks. This is a matter. Of
Very well. I'll produce a record.
The score is scheduled.
No, Lordship, because we have one as per rule, Lordship. We want tender only.
Okay, then we'll make it shorter also. Make it
Very-
2 weeks.
Very well, Lord.
2 weeks. This is the matter. Give it.
Obliged, Lord.
Obliged.
Made equal of the matter pertains to non-payment of contract. Similar matter.
Give me. You don't have any order. Again, out here petitioner's husband. Or what?
Oh, yes.
Okay, give me.
Liability statement.
Have you got any order? Again, I'll have
Yes,
to.
your lordship, I have attached.
No, you have next.
Yes, your lordship. Nothing.
No, not this. Give me that 1280 of 24. 1280 of 24. That is good.
Lordship, I have attached. 4734 of the 2020. Nothing. Page number 25.
Page number?
25.
No, those are the bunch methods.
Yes.
I'll just print out. Slightly different. Where is the admission?
Lordship, on page number 90. An extra 4. Page number
90.
90.
And where is the forwarding letter? Page 17.
Yes, sir.
Amount is
Lordship, account is 2,28,287.
2,28,000.
1,287.
This is item
30.
Yeah, Miss or Mrs.
Yes, sir.
E.J.
Yes, sir.
And Jan is here or what? So you'll be for 2 to 7.
Yes, sir.
Is this Moregaon again?
Yes, your lordship.
All
Two work
Moregaon.
orders were issued.
Huh?
Lordship, 2 work orders were issued. One is from Moregaon and one is from Nagaon. But the liability statement is issued by the Moregaon department. Executive Engineer of Moregaon, Water Resource Division, Moregaon.
Where is that? The one was with regard to the same RS2 T dike.
Yes,
Uh,
your
long
lordship.
course. Same thing.
Yes, yes.
So 2 work orders with
Yes,
regard to. So certain amount of money was given to you.
Yes, your lordship. 7,100.
2, 28,287. Okay.
My pleasure.
Yes. What to do?
No, admission is 2011 was.
Where's the admission?
Page number 25. Statement showing the details of the account for payment of payment.
Page 20?
25.
25. Details of account payment.
44,198. And next, page number 19.
No, this details of account of payment. Where's the details of liability?
Liability,
Dues.
my lord. Payment already made, 77 lakh given. Present bill value. Present bill.
Present
Bill of
bill.
30,
Where have you got that word present bill? Present bill value.
Present bill.
3 cents. Now bill pass for 3 cents.
Bill
So
It is,
what
it is same product.
payment now made. So what is wrong? Where's the admission?
This is the admission, my lord.
It's not the admission.
Or page number 19, my lord. This is the bill.
It's not the admission.
Final earning bill. 3,34,109. Page number 9.
Okay, anyway, still correct. Heard, mister?
Keep it.
Keep attack.
Keep it.
Learner counsel for the petitioner who submits that the petitioner's contractual bill amounting to rupees 3,34,198 has not been paid. If you notice returnable service, it's the fee of who excess notice on behalf of PWD group. All the respondents. This is a matter of the service to enable the respondents to obtain, to file affidavit.
It is basically intimated the registry that file is being taken out from us. Okay. Appearing for a day.
Okay, so you are not, so you have disengaged yourself. Where is your letter notice? Okay, right. In terms of the order dated 29/5/2020. Mr. M.I. Hussain has submitted a letter to the registry informing them that the petitioner has taken back the file to engage another company. However, no one appears on behalf of the petitioner. Yes,
Appearing for election commission.
very far,
For election commission of India.
we have not issued notice.
But I have.
Huh?
Last time I have appeared.
You appeared, but your name is not reflected here. We have not issued notice. What to do? You still want to appear?
For director of figures matter.
Right, Mr.
H.
H.
H. Puli.
Uli. Spelling
H. AULI.
KULR. Appears on behalf of
So AI.
AI Ali.
AI.
Learned counsel for the narrated petitioner. In the interest of justice, this is the matter again on Thursday. This Thursday. You don't need to appear anymore. Okay, what a matter. No, before that. Mr. M.I. Hussain just submit that he will not be appearing for the petitioner any longer. of liability. So Thursday, if they don't appear, we're dismissing it for non-prosecution. Now, huh?
We have changed up.
Happens. Now let's see. We have to.
The petitioner is before your honor. Is the present. At present. At present, under in contract with the oil. At present, they are in contract with the Indian Oil Corporation.
That period has expired, I think.
No, it's been extended time to time.
When is the extension?
No, Lord, he is still continues.
But period has expired.
So, period has passed, but dear Lord,
He's continuing, but not on the basis of any written contract.
no, written contract. Sir. Hearing.
Where is the written contract shown?
Yes, one. But you can go to the order dated 47,
Page 47.
47 Lord.
Yes, this 47.
In the 47 Lordship, here in 28/9/2023 Lordship, extension of tax LPG tender, we are being extended. Lord.
Page 47. Where are you reading?
First part.
Dated 10/7/2017.
No, 28/9/2020. Annexure B. Annexure C, Lord.
Annexure B. Annexure B. Where is Annexure B? Huh?
C, Lord. And then
D for Delhi.
D for Delhi.
D for Delhi. Page 48.
Here, Lord. And the extension of tax LPG tender, Lord.
Yes,
Here, Lord, we are being extended up to 30/4/2023.
correct.
And here, 30/10 to, we have given the PG,
Huh?
31/10, we have given the PG letter part. Bank guarantee up to 31/10/2024, Lord.
Okay.
Then turn to next part, Lord. Next part. We are still continuing, it is 29 May 2020. We are still continuing, Lord.
Where? 29 May 24.
Yes, this is a challan, Lord. Lordship, they will say, Lordship, they are still under their contract.
No, but then not an impossible thing. You have been allowed. You have been allowed to continue,
No,
but
that is it.
it's like your fishery. Then you'll understand. Your fishery is up till May 2024.
Right.
So 30th May that fishery expired correctly, but he still continues.
But here,
So it's like that. So that
no, in sorry, Lordship, there is a problem that we cannot go for, we have to go for position that part is. Here, they are allowing the gate pass, Lordship. It is a very, that is a very protected area, Lordship. They allow the gate pass, everything.
okay then.
And also, Lordship.
So
I'm not on that,
you're
Lordship.
continuing beyond your period.
Yes, I'm continuing beyond my visa. Lordship, sir,
So what is your grievance then?
my grievance is that, Lordship, that in the year 2023-24, Lordship, they issued the NIT.
NIT dated?
NIT, in NIT 23-24.
Dated.
This Lordship in the E4 Lordship, there is no date Lordship. 49 Lordship,
Page 49. Which page date? 50, you mean, page 50.
50 Lordship.
So there is no date to this NIT. Are you sure?
No Lordship.
Okay, so what is wrong
Here
with the
Lordship,
NIT?
here in the Lordship can go to the page number 53 Lordship.
Page 53.
There is a clause Lordship, the bid sales is summarily rejected. If bid security declaration in your AMD is not uploaded in the tendering portal on or before tender submission date and date. Here Lordship, the
What is EMD?
EMD we have to give an affidavit.
No, what is the full form of EMD?
Earnest money deposit Lordship.
Earnest money deposit.
Under earnest money. Okay.
Yes.
So in here, we have to give an affidavit that we will give the earnest money. So that's what. here the case starts from here, Lord. They are arbitrariness. I am managing arbitrary.
So are you challenging the NIT or what?
Yes, I'm telling you. No, I'm not telling you. I am on that part, Lordship, that they use the what they are while selecting the tender process, there is a favoritism, there is a biasness,
Okay.
there is an arbitrariness.
So who has been selected?
Here, Lordship, this respondent number, this is being in the body of the. Here, Lordship, before going to,
No, who has been selected?
either Lordship.
Actually, but which one? That's point number 6, 7, 8, 9.
So, return number 6 2. That's point number 6 2, Lordship, 17, Lordship.
6 to 17 for transportation of LPG. For transportation.
Yeah.
You have not been selected.
I have not.
Why?
That is, yes, I understand. I did a mistake, but that mistake was the Lordship. I might fall,
No. Just tell me one thing, first of all. Why was your bid not selected?
my bid was not selected because I have not uploaded the EMD at that relevant point.
You have not uploaded the
Yes.
EMD.
Yes.
So this page 53, you have not followed. You
I have not complied.
not complied. So there is, so
Then
you,
there is a relaxation from their part. After 31st, I have to give this after 31st of January, not
31st of January.
January 2020.
So you gave it.
No, after 31st of January, Lordship, I filed an application, Lordship. That is 14.
No, tell me one thing. Your tender was rejected because you did not comply with clause number 4.
Not-
Correct? Earnest money deposit. So they have rightly rejected your bid.
Yes, at that relevant,
At that relevant time, they have rightly rejected.
but later on, I came to know that it was because of favoritism and nexus with the reference.
No, that is a different thing. But then they have a right to reject your bid if you do not comply with clause.
Sure.
So there is,
But
so have you challenged the rejection of your thing?
Yes.
On what ground?
that is the fact. That is the fact. I have, that is 230 pages. Lordship was 230.
Page 230.
Not-
Petition is thick. Let me see if it has merit.
Not-
Sometimes very thick petitions do not have any merit.
Right. But it is,
Thin ones have.
merit is being tried to make out.
Yes,
Here, Lordship, on 14 to 2024, Lordship.
page 230.
Not-
230?
It's a representation. Annexure 6, Annexure G, Lordship.
Annexure 8, G, G1.
Only G, Lordship.
Oh,
That is 220.
the date,
That's 14 to 2020.
It's 229.
And long
Right.
regulation.
yeah, page 18, from 229, you are jumping to 250. And then from 250 is, that is 230. Okay. 229.
Yes.
Page 229. 14 to 24. This is your letter.
Yes, Lord. Request to allow Narayana of vendor to submit bid security declaration in lieu of EMD. Lordship, as because they have relaxed in the case of the other respondent, which we came to know, so we also filed an application before declaration of the NIT, Lord. Result, Lord. Tender process, which is
When was the final select list made?
27 to 2020.
27 to 24. So you are asking that you should be allowed to submit the bid security declaration.
It's security document. I have given, and I have given the copy also. This security, this file also.
So you did not submit bid security declaration or EMD at all earlier.
And before that,
Yes.
at all.
Now, who amongst the private respondents did not comply with this clause
Got it.
4 also?
That is here we have the here Lordship. my allegation is that lordship will be fine. There is also something sitting in this case, lordship. Give me some evidence. Some, if lordship, I can convince lordship. There is this respondent number six to all the respondents which I stated, is has the vehicle provided by them is an assembled vehicle. That are all assembled vehicles. This is in two lordship, Tata Motors, and I have secured today lordship from the this also. There's this government of some this website also. That these are of Tata made, but these are not of Tata manufactured lordship. All vehicles are because of providing benefit to them lordship, benefit to this respondent lordship. They did not allow us to give us to
No,
provide.
no, Mr. Counsel, you see, that the first question has to be, the first hurdle is with regard to your NIT. You did not comply with clause 4. Then you wrote a letter on 14th February 24, asking them to allow you to submit a bid security declaration in terms of clause 4. You said that other people were given the same facility, they were allowed to submit bid security declaration instead of EMD later on, after opening of the tender. Is that correct? Yeah?
Not on EMD lot. Other mandatory documents they are allowed. In the
Okay, not on the EMD.
not on the EMD.
Say that. Then what is
Not on
wrong?
the EMD lot. The other mandatory documents I have stated.
Then you have got no case.
Lordship.
Then you have got no case.
Here lordship.
Ronak International, Tata Motors, those two judgments are there.
Lordship, here lordship.
If you are not eligible, you cannot challenge the selection given to others.
But here lordship, here my case is there lordship. These documents are stated to be mandatory in nature. And other mandatory documents they are being allowed. Lordship. They are being allowed to fulfill after 31st of January 2020. My specific allegation is there.
But then you should say that for EMD or that bid security declaration, those others, if they were in the same boat as yours, that's okay. Because you see, with regard to essential conditions of contract, there has to be some loose joints which the author of the NIT can play around with. It is up to them. They can play around with the joint. But then for you, you'll have to say that for clause 4, you were rejected, but others were also rejected and then they were allowed, then you've got a case. But if you were rejected on clause 4, only you and not others, then you've got no case.
Lordship, not on lordship. Clause 4. Kindly go to the clause 4 lord.
Yeah.
Clause 4 lord.
Yeah.
Clause 4.
Clause 4 says what?
Clause 4 so it is mandatory document.
Yes, it shall be
Yes, that is-
summary,
yes,
the bid
I
shall
am
be
the same
summarily rejected.
I am on the same footing lord. Lordship,
What is same board?
page number 18 lord.
I don't think you've got any case.
Lordship, kindly go to page number, page 1, page number.
And
Not
Yeah,
these
page-
documents. My allegation is that page number 66 lord. Page 66 lord.
yeah, allegation is page 66. Yes, what about page 66?
Yes, other mandatory documents to be submitted by the bidders
Wait, page 66.
in the tender notice it is near page 18 note.
Huh?
In the tender NIT, this NIT
Page 60?
6.
Well, how does it start?
Other mandatory documents.
No, it doesn't say that.
No, it's
Not
67. It is
Huh?
67. 67.
67. Yes, other mandatory documents, yes.
Yes. Other mandatory documents to be submitted by the bidders participating in the tender.
Uh,
My specific allegation is this part they allowed them, they have given notice that they allowed them to fill the letter. But it's a mandatory document.
where is that?
This is my
Specific
allegation. This will come only in
allegation has to be proved.
Lordship,
You
that will come when they produce the record, Lordship. Because Lordship, my fact is that Lordship, here Lordship, one thing, Lordship, here there is this vehicle which was put by the respondent is not of that Lordship. Is it kindly go? Yes, sir, please.
No, no, I cannot go into the father. You see, the first hurdle is your rejection. If you can show that on the same ground, other tenders were allowed, while yours were rejected, while yours was the only one that was rejected, you've got a case.
Other,
Did, were any tenders rejected or allowed? Were other tenders allowed despite violating clause 4?
yes, Lottie, yeah, here Lottie, the allegation is, they are saying, my petitioner is saying that they are being allowed to go for mandatory document. They say their Lordship, my allegation is that the first, Lordship, my draft of this petition,
No, no, the trucks will come secondary. Those are secondary issues. First issue is you have to be eligible. Unless, supposing we allow the writ petition, then what happens? They don't get, you don't get, no one gets.
no Lordship, here Lordship has to go from downstairs, Lordship, here in this case, but not for the hurdle. So this is a hurdle,
You
Lordship.
have to go from downstairs from where? Downstairs where?
Downstairs means Lordship, the vehicles provided by the respondent number 2, respondents, Lordship.
That is
These
not
are all,
secondary.
these are all assembled and
We file a PIL for that because you're not eligible. No right of yours has been violated. You see, it is not your case that the rejection of your tender is bad in law. It is not your case. If your case is that it is bad in law, okay, we'll examine that aspect. But it is not your case.
But
It's
my rejection is
It's
that
a case of
there,
star
there
grade.
is a, as because they have allowed, in spite of knowing the Lordship, my simple fact Lordship in the downstairs Lordship, as the vehicles are of fraudulent, they are assembled vehicles. They are not of Tata Mech, but they have stated it in the Tata Mech. Tata has stated that they are not of.
That is a different issue.
For that reason, Lordship,
You file a PIL.
but can Lordship give the liberty? Can I ask for a liberty, Lordship, to file an application?
PIL is before DB. Who am I to give liberty?
But I may, that also, I'm praying for.
If you want to withdraw, I can give you liberty, withdraw with liberty to approach the appropriate forum in an appropriate procedure, appropriate petition. With appropriate
Lordship, here, Lordship, here, but here, Lordship, before withdrawing, Lordship, I need one minute, last chance, Lordship. Lordship, here, I'm going from the downstairs, Lordship. The vehicles are being given here as assembled, fraudulent receipt. Lordship has gone to this document, Lordship.
I have not gone through. Why should I go through? I don't want to burden myself with that when you have got no right. First of all, to come to a writ court, you have got to show that your right has been violated. Then only we will see whether your right.
My right is violated by favoritism and arbitration.
No, but at the same
Because Lordship, these vehicles are being assembled, Lord.
at the same time, your tender is not as per clause 4, and clause 4 says if you do not submit these documents, your tender will be summarily rejected. Now this clause 4 is also not put under challenge. Nothing.
Lordship can go with the liberty to file application for us, including care.
I cannot say PIL. I can just say may approach the appropriate forum with an appropriate petition. That's what I. That's what. Because we have got no case.
Lordship, here I have a case, Lordship.
Your case should be at most operation successful, patient died. That's all. Because you see, you cannot get the contract anyway. You have not even crossed the first hurdle.
Because, but here, Lordship, so that hurdle, I have filed an application. That petition is not in disposal.
No, that doesn't matter. Your petition doesn't give you any right.
Yes, Lord.
That's your petition. Just because you write a letter doesn't give you any right. Yes, Mr. Chaudhary, anything to say?
I don't want to add anything.
So what are you going to do?
We get appropriate for us.
Okay, right. Mr. P. Sharma, Direct Counsel for the petition says that he may be allowed to withdraw the writ petition with liberty to approach the appropriate forum by way of an appropriate petition. Mr. M.K. Chowdhury, Senate Senior Counsel, assisted by Mr. P. Bhardwaj, appears for the IOC. The prayer of the petition counsel is allowed. This petition is dismissed as withdrawn, with liberty as faith.
After trying lordship.
No, but then when your tender, if the rejection of a tender is wrong, then okay, but you are not challenging the rejection of your tender. There's nothing wrong.
Okay, can it be one more prayer lordship? You can liberty to file FS also if necessary lordship. Yeah?
No, that no. If they are praying for that, then I'm going to dismiss with reasons. Item 16. No one appears for the petition on call. And these disputed questions of fact, I think. Huh? Nothing. But what are they're not here? We'll dismiss it. No one appears for the petition on call. Mr. B. Gogoi appears for the PWD bracket rule. The petitioner has prayed for payment of its contractual dues amounting to rupees 59,80,540.94 in respect of the work of construction / improvement of Big Boy Pengari Baldungsa Road, bracket 1st to 5th km, close, bracket package number J-6, bracket close, under NEC's 10th 5-year program, by work order dated 17/9/2007. Issued by the Chief Engineer PWD bracket, no, comma, NEC Works, comma, Assam. But it is not the work order, it is notice to proceed with the work. Huh? Work order is nothing else. It is the notice to proceed with the work. Acha. Okay, just say NEC's 10-year, 10,
My lord.
10 5-year program. Puspa.
My lord,
Others you cut. Yes.
I appear for the petition.
Yes.
And I appear for the, cannot pray for a 1-day accommodation, my lord.
Why?
Actually, this case was conducted by J.K. Parajuli. He cannot appear, my lord. It was handed over to me this morning. Can it be taken out?
There is nothing here. There is nothing here. There is nothing here because out here, you see, the thing is that if you look at, give him the second copy.
No, I have collected the file this morning.
No, we'll give you our copy where I'm disposing it of. What is the name?
S.K. Chakraborty.
Mr. S.K. Chakrabarti appears for the petition. Come to paragraph 4, 5, and 7 of the affidavit of response number
File.
5.
But my lord, he himself has written to the authorities of IOCL and AGCL that remove the hindrances because of which the work is, there are some because of which work is not progressing. He himself has written. I will kindly see the letters written by the
Mr.
authority.
Counsel, this is a contract matter.
Yes, ma'am.
This is not an issue before that can be decided by a writ court. There are two aspects. If it's a contract matter, if you are asking for contractual dues.
Yes.
Now, either you go to civil court or you go for arbitration. If there is an arbitration.
In the affidavit, my lord, he has admitted that the 2 kilometers were, there were hindrances. At least what that 2 kilometers there, consider my bill then. My lord, can you see paragraph?
You see, there has to be an admission. In terms of.
The paragraph 4 of the affidavit in the book.
Yes.
That with regard to the statement in paragraph 3 of the writ petition, the defendant state the work allotted to 1 to 5 kilometer, the site from 3 to 5 kilometer was free from any encumbrance. In the first 1 and 2 kilometer, IOCL water lines and AGCL gas lines and electric posts were present on the both sides. There were obstruction matters because of which
Carry on reading.
the main road was free from the contractor did not carry out the main road work on the pretext of presence of hindrance.
So you see, the issue is this. If there is an arbitration clause, you go for arbitration.
No, matter there is no.
Then you go to the civil court. And this was pertaining to which year? 2007.
7 years.
Huh? Then 2007, and you come to this court when? 2017.
Yes.
When did you make your bill?
2013, my lord.
2013.
Yes.
You made your bill. And
Yes.
2017 you come to the court. How can we decide? How can we decide such issues? Right. What is the affidavit of the respondent number 5, who is the executive engineer, PWD, Tinsukia State Road Division, Tinsukia, gives to the following effect.
And it is also, my lord, 1 minute, my lord, please.
Have you finished the contract work?
My lord,
Did you finish the contract work?
yes, yes, my lord. It was, lordship, kindly see page number 64. While forwarding the escalation bill, my lord, last paragraph, my lord. From the above observation, it may be concluded that the contractor deserves price escalation for delay in execution only for the first and second kilometer for the road length and remaining 3 to 5 was clear of road. But it has been written to the chief engineer by the superintendent engineer while forwarding my escalation bill.
Is there any forum he can go to, Mr. Gogoi? How will he, the 2007 matter, how will now, who can decide all these issues?
Whether it will be bought, and my lord, as far as it will only 49.3%, 30% was into the execution of that. And the present petition has been instituted only against the adjustment bill. But we will see the prayer, man. Yes, what are you about? Page 9.
What is it? No, from the beginning.
Yes.
No, from the way, right. Payment for his price adjustment, a contractual bill, amounting to rupees 59,000. Plan, which had been started, which had commenced on, which had commenced in the year 2007,
Madam, 17/9/2007.
which had commenced in the year 2009, which had commenced
Madam,
in the
page
year
60.
2007. To start. The bill amount of rupees 59,80,540.94 is for payment of the price adjustment bills of the petition. Next para, the petitioner, then whatever I said after that. That's all. Next para, the petitioner constitutes something that the petitioner completed his contract work after clearance of the
With time.
roadside in the year
My lord, can you see 64, second paragraph, my lord, there. It's 36/2012. Second paragraph, the work started on
No, when did you complete?
36/2012.
Okay, on 30/06/2012. And he submits that the price adjustment bill relates to the price escalation for the delay in completion of the contract. Next, Mr. B. Gogol, Leonard Counsel for the PWD submit that the petitioner had completed only 49.30% of the contract. And the claim for escalation for work done it could not be entertained as it was not, as the work was not completed within the stipulated time of completion. Now, what is to be done? Where to go for him?
You have to be provided to the chief engineer to have a.
Next para, right? Next, right? Para 4, 5, and 7 of the affidavit of the respondent number 5 status. So what is to be done here?
You wanted to verify if anything is found to be due as on date.
My lord,
But then since they have said this in the affidavit, what is there to demand?
That's what.
since superintendent engineer says, my lord, I am entitled for 2 kilometers of price escalation. That may be considered. The last page that I have told 64, page 64, last paragraph.
Well, you see, out here says but the work was completed on 6 with extension up to, but without price adjustment. And you're asking for price adjustment.
I reading the admission of the superintendent engineer himself, my lord. He says, I am entitled to that.
No, it doesn't say that.
Last paragraph, my lord. From the observation, it may be concluded that the contractor deserves price escalation for delay in execution only for the first and 1 and 2 kilometer of the road length. The remaining 3 to 5 was clear of all incumbent. All documents are enclosed here for favorable candidate.
I say the main road was free, but the contractor did not carry out the main road work. Affidavit is there.
Prior before the civil code or if there is any arbitration clause.
Is there any habitation clause?
That agreement is not in place.
Where is the contract agreement? Have you got it?
No.
Very difficult because this also 2020. His superintendent's letter is also of 2020. Or what? 2014.
7 to
2014.
2014.
14. There's, what is there to do? We are left at the discretion of the authority only. Yes. Next, on perusing the amendments made by the point number 5 in its affidavit. Comma. This court, this writ court is not equipped to come to any decision as to whether the petitioner is entitled to any price adjustment as paid for by him in the writ petition. Further, the further para 4 of the affidavit of the respondent number 5 states that in the first and second KM IOCL water line and AGC gas line and electric poles were present on the site berm, BRMS, berm. Full stop. The main road was free, but the contractor did not carry out the main road work on the pretext of presence of hindrance on the site berm, BRMS. In para 5, it has been stated that the physical progress of the work was 49.30%, while the petitioner has taken the stand that he has completed the contract. It is also not disputed that while the stipulated date of completion of the contract work was 16th of 2008, the petitioner had completed the work on 6/6/2006 only. As such, para 7 of the affidavit in opposition states that the petitioner's claim for escalation for work done within the stipulated time of completion could not be entertained. Next part. The above amendments made by the state respondent even if disputed, would have to be put to challenge before appropriate for by recording evidence. The above being said, yes, sir. The above being said, the letter number F-14/PT/09/187/278 dated 7/2/2014 issued by the superintendent engineer, PWRD, Jorhat NEC Circle, which is at annexure M of the writ petition. Is to the following effect. Page 64 of the writ petition. The above letter dated 7/2/2014 shows that the contractor might deserve, no, the contractor could deserve price escalation for delay in execution only for the first and second km of road length. However, the same has been negated by the state respondent, by the state respondent number 5 in his affidavit dated 7/9/2017. As there are disputed questions of fact involved, this court, as stated earlier, is not in a position to take a final decision on the issue raised by the petition. As such, the petitioner is given liberty to approach the appropriate forum, including the civil. However, till the same is done, the respondent number 3, 4, and 5 may once again look into whether the petitioner deserves price escalation for the first and second km of road length in terms of the letter dated 7/2/2014 issued by the superintendent engineer, PWRD, Jorhat NEC. The decision taken by the respondent number 3, 4, and 5 will thereafter be communicated to the petition. That's all. Well, the petition, the foreign report. Nothing beyond that can be done. 2017 matter. Stop. The exercise to be undertaken by the respondent number 3 to 5. Maybe it should be concluded preferably within a period of 6 months. Period of 4 months. Monsoon time also, no? Period of 4 months from the date of receipt of a certified copy of this order, along with a copy of the writ petition. So your amount is admitted.
Lordship, admitted in their affidavit, Lordship, paragraph 6, Lordship.
Yes, who's appearing? Panchayat and Rural Development. PNRD. Ah, yes. Yes, madam. Admitted?
That's it. From the higher authorities, waiting for instructions from the higher.
Who speak for your authority? Oh.
So Lordship, otherwise give a direction to the authority, to verify.
No,
Admitted already, Lordship.
no, you see, the problem is, as per Tamsher Ali, the head of department has to verify.
Lordship,
Out here, it is done by the junior engineer.
Lordship.
So let the head of department verify and we'll dispose it of that within a time frame. That is as per Tamsher Ali. What to correct? Heard Mr. K. Mazumdar Learned Counsel for the petition. And Miss
And Bora,
N. Bora for
all is response.
all the response. The matter pertains to non-payment of contractual dues amounting to rupees 31,69,43. Miss N. Bora, the learned counsel for the respondent subject that as per the physical verification report made by the junior engineer, which was submitted to the block development officer, Hailakandi Development Block. The petitioner's claim of supplying materials for construction of PMGSY road to E&E Bund via the house of Arif Ahmed at village Gamkpar, Dumtar, Part 4. It's in annexure 4 of the, no, para 4 of the affidavit of position. Huh? Part 4 of Narayanpur, Tub Khana GP and the MGNREGA for the year 2016, 17. The value of which was rupees 39, 79, 034. The petitioner has been paid rupees 74110. As such, the remaining balance amount payable to the petitioner is 31, 69, 432. He submits that as the admitted amount has not been verified by the head of the department in terms of the judgment of the full bench of this court in Samsher Ali versus Union of India, reported in 2008. What? The writ petition can be disposed of if a direction is issued to the who is the head of department?
Commissioner Panchayat and Rural Development.
To the principal secretary to the government of Assam Panchayat and Rural Development Department to re-verify the amount payable to the petition. So thereafter, the admitted amount can be paid to the petition. On considering the submission made by the counsel for the respondent and keeping in view the judgment, the full bench judgment of this court in Samsher Ali Supra. This court directs the principal secretary of the government of Assam, PNRD, to re-verify the contractual dues payable to the petitioner. Thereafter, the same should be paid to the petitioner. Thereafter, the admitted amount should be paid to the petitioner. The entire exercise should be concluded within a period of 4 months from the date of receipt. Huh?
4 months.
4 months from the date of receipt of a certified copy of the cost. Verification is accordingly disposed.
My last total losses, they did take a snap for us.
We have not received any instruction, my lord. After that instruction, my lord, whether
Huh?
payment has been made or not, my lord. Sanction was,
Sanction made.
sanction not made, my lord.
Huh?
2021, my lord, letter was issued to us, my lord, saying that, my lord, they have placed before the higher authority for sanction.
That is my last total.
Mr. G. Bokaliel had said that he has received instructions to the effect that the bill amount of the petition is being processed.
Okay. Now, their instruction, whether, my lord, there has been process has been completed or not, that has.
Huh?
We have, their instruction we have not received, my lord. We have also the instruction letter, my lord.
So was Mr. Bokaliel telling me a lie? Was he telling the court a lie? Huh? He was lying to the court.
No, my lord. Instruction was for, my lord, whether, my lord, payment has been made or, my lord, sanction has been granted or not.
He said that it was being processed. So what is the status?
There is, there status, we have to.
We'll call the officer, I think. You are not getting information, 2021 matter.
Only one more time, my lord, I will. Take it up.
Mr. L. Mohan appears for the petitioner. Mr. M. Chetty appears for the state response. The matter pertains to non-payment of the hiring charges of the petitioner's vehicle by the respondent. In the last order dated 18/10/2023, it has been recorded that instructions have been received by Mr. G. Bokalian, Junior Government Advocate, that the bill amount of the petitioner was being processed. Comma. Now, full stop. Today, Mr. M. Chetty has submitted a letter dated 16/8/2021, issued by the Deputy Commissioner of Police, Crime, Body, which is to the effect that the bills of the petitioner were verified and forwarded to the Office of the Director General of Police, SM, sanctioning authority, for according sanction and for according sanction of fund required. Next. paragraph. It is surprising that the government advocate, the junior government advocate, had informed this court on 18/10/2023 that the petitioner's bill amount was being processed from a while. Today, the letter dated 16/8/2021 is being produced. Mr. M. Chetty, wait for time to obtain instructions as to the status of the petitioner's bill. List the matter on, give a date. When? In this. Give a date. Give me the date. 21.
Item 24 so similar type of time.
Item 24 same.
22.
22.
Two are typically
Okay, item 22 also same. Huh? Same order. Only, have we mentioned the amount? Amount,
mention this amount, but no inspection, no exhibit.
amount is different will be.
Amount
Amount will be different, huh?
In this was the 22 mile item, amount of 33 lakhs has already been paid back, but 5 lakhs is.
Just a minute, then, just wait.
Next is your okay. Next is your okay. My lord, here the petitioner is aggrieved by the imprint comparative statement lordship at page 52 lordship,
Page 52.
page 52 lordship. The imprint comparative statement lordship, where in lordship, in two columns lordship, the authorities mentioned that bank guarantee, I have not given any bank guarantee.
Page 52 is the comparative. Your name is
So number one lordship,
number 1.
Shubal-
So what is your the offered amount?
lordship, that offered amount also, they have mentioned that lordship below minimum value.
No, but what is your amount? 66,
Lordship, I have offered lordship, the value
78, 68.
lordship for first year, 12,65,000.
Ah,
Page 28, lordship.
yes, yes.
Page 28 is my offered value, lordship. 22, 23, 12,65,660.
Just a minute. Page 28.
Page 28, lordship.
Yes, first.
22,
Sure.
23, 12,65,660. 23, 24, 700. 24, 25, 12,65,800. So like that lordship, up to 28, 29, 12,69,000. So, and minimum value which they have mentioned, minimum tender value, 11,50,000. So my tender price is more than that. So how they have make
Calculate.
such a statement, lordship?
Anyway, okay, so it is above 78 lakh.
Yes, lordship.
So it is above 80 lakh.
Because
It is above, it is, it comes to around 89 lakh. Yes, it comes to around 89 lakh.
so 96 lakhs, lordship.
Okay,
More than 96 lakhs I have.
how 96?
Because lordship for entire 7 years.
Correct, but 12 sevens are 84.
Yes.
12 sevens are 84. Then this 65, you take this 65 into 65 into 7, 42, 4 lakh 20. Say this is also take 5 lakh. It comes to 89 lakh only.
Yes,
There's not 96. There's no question
more
of
than
that.
minimum tender value.
Correct, more than minimum. Correct. Then
So that's, and also in bank guarantee column, lordship, they have stated that nil.
okay, leaving that aside.
But I have given the bank guarantee, lordship, that I have annexed.
No, Mr. Counselor.
Yes.
The private respondent, what is his bid amount?
His bid amount is more than me, lordship. But the fact is that, lordship, as now, lordship, your lordship may kindly peruse page 54, lord. Because the bid amount which was tendered by the private respondent, lordship, that is more than entire history, lord. So now,
More than entire history?
that meaning thereby, lordship, since 2004-5, lordship, that bill was, lordship, settlement was done, but entire this period, lordship, the amount which was offered by the lordship, tenderer, lordship, that was much less than that, lordship. So now, lordship, so far as my knowledge, lordship, the private respondent is not interested to take the lordship. That
That is the issue between him
yes,
and.
lordship. But as per rule, lordship, then next bidder shall be given the tender, lord. But I was shown as not eligible.
No, that's okay. Okay, we will say that you are eligible, but your bid is less than the bid of the thing.
If respondent number 7, private respondent is failed to take lordship, then the
I don't know. That is a different issue.
But, so that comparative statement may be lordship corrected by them, because I have given everything.
Has the settlement been made?
Settlement still not made, lordship, because, as per my information, lordship, the private respondent is not ready to take it.
Yes. So he wants correction of his, correction of the comparative statement.
Lot of, yeah, I have 6 year average, 11 lakh. A, B, C, D.
Just a minute. Come to, where is that again, that thing? Comparative statement, where is it?
December 52.
Huh?
52 lot.
52.
52.
Yes,
Here lordship, kindly go to the column number D lot.
D.
D lot.
Yes.
6 year average yearly revenue 11 lakhs, something 483 lot.
Yes.
Here minimum tender value in the upper part 11 lakhs, 11 lakhs 50,600. This below, that is the reason lordship. Yes, put it this way. Yeah.
That is entirely false, lordship, because I have annexed my bid value, lordship, at page 28. Wherein, lordship, all the amount was more than 12,65,000. So,
Let us, you bring the record, let us see how much he has. You bring the records, let us see.
30.
What? No, no,
Then also lordship, here lordship, the first bidder. Here, we follow one in the tender bid that we have not annexed the whole NIT lot. In the NIT lordship, if they have to take the field lordship, we are ready to give it.
they have to give the first bidder's thing.
I'm ready to pay.
Are you ready?
I am ready to
Okay.
take it.
As per the first bidder's bid amount, right?
No, lordship, because, lordship,
I
because
ready.
first bidder is paid, lordship, then my tender will, because
Huh?
We are ready. If he says that he's going to take the bill, I'm ready.
At what? At what
At the
rate?
rate of one, the first bid.
As per the first bidder's rate.
I was in the NIT lot. We have not NIT.
Oh, okay.
It is getting away.
Oh, that is why.
That is why.
So we'll say that, okay, if there is any miscalculation in terms of page 28, in this page 52, let the comparative statement be made and bid amount has to be given as per the tender condition. Correct?
Okay, no, bid amount. If
That's what you said.
my standing is that if when the first bidder is to accept, we there is in the NIT, there is a clause lot. We offer to the second bidder. Second bidder has to take at the rate of first.
It's specifically stated.
Specifically stated.
So that's why we will say that then we won't say that it should be given to him or to the other one. We'll just say that the settlement should be made as per the clauses of the tender notice. That's all.
Not before it.
That's all. Third, Mr. N.H. Gorbuya, learned counsel for the petitioner, who submits that the petitioner submitted his bid in pursuant to the tender notice number 1 of 2022, dated 14/3/2022. The petitioner's counsel submits that the petitioner's bid was rejected on the ground that his tender was below the total minimum tender value for 7 years
and bank guarantee.
for rupees 8, that is rupees 80, 54, 200. So, sir, he submits that in the comparative statement made by the state respondent, the petitioner's 7-year grand total bid amount has been shown as 78,68,560, which is not in consonance with the rate quoted by him in his tender document. Full. He submits that the rate quoted by him in his tender document would show that the 7-year grand total bid value of the petitioner would be above 80 lakh, above 81 lakh, above 81 lakh. Next. No, next, the petition counsel thus feels that a direction should be issued to the respondent to, uh, to re-verify the bid amount of the petitioner and to make necessary correction to the comparative statement with regard to the total bid value submitted by the petitioner. Puस्तक. In this regard, he has relied upon page 28 of the writ petition in support of his submission that the petitioner's total bid value for 7 years was beyond 81 lakhs. Puस्तक. Next, Mr. P. Sharma, the learned counsel for the AFDC, submit that the AFDC will conduct a re-verification of the petitioner's bid amount, and if it is found that the petitioner's total total bid amount was beyond 81 lakhs, the petitioner's tender would be declared to be a valid tender. Provided he has provided all other eligibility criteria have been fulfilled by the petitioner.
Yeah,
Full stop. He further submits that in the event the respondent number is it made a party.
Yes, sir.
He further submits that in the event the
No, 5 law.
bid of the respondent number 5. He further submits that in the event the respondent number 5, whose bid of rupees 1,41,64,090. No,
they have offered, settlement.
he have already offered,
Oh, I have already offered.
but he has declined.
Yes, sorry, I have not written, his decline.
What am I saying?
Yep.
If he declines settlement of the fishery, the offer of settlement of the fishery would be done in terms of the clauses in the terms and conditions of the NI. Would be done with the respondent, with the petitioner here, in terms of the terms and conditions. Provided the petitioner verified bid amount is above the minimum tender value and the fulfills all the other criteria required in the NI. In view of the submission made by the counsel for the party, there is nothing left to adjudicate in this matter. Accordingly, the respondent shall re-verify the bid amount submitted by the petitioner. And if the petitioner's bid amount is above the minimum bid value set by the respondent, the petitioner's bid value would be considered, petitioner's bid would be considered to be valid, would be considered to be a valid bid, provided he fulfills all other eligibility criteria required
And the
in
event,
the NIP.
even the respondent number,
Full stop. That's all. I have no need, you have already stated that. That is petition is accordingly. I don't have to give that direction. If you do not give, he will come to court again. But how do you want me to say it? I can say, it.
that is our standard rate, lot.
Huh?
We normally give to the second bid at the rate of 5. We offered lot. I think
so do you want me to reflect that?
that can maybe reflected there, we all,
That's what terms of the,
Tender the tender, no.
yeah, also, my submission lot. That is the real lot.
That I will clarify that. This petition is accordingly disposed of.
Apply.
No affidavit.
Lordship, we have received instruction, Lordship. This claim was, Lordship, 38,69,944. We have already paid him, Lordship, 33,37,622. And remaining, Lordship, 5,32,322 in respect of two vehicles, Lordship. Petitioners agreed to 20% negotiation. And so they have to file undertaking before the authority. Then, Lordship, after he will be submitted. Yes, will be
Okay, right. Alright. Mr. Yeah, L. Mohan, after for the petition. Who submits that the petitioner vehicle hire charges amounting to rupees 38,69,944 has not been paid. On the other hand, Mr. K. Gogoi, appearing for the respondent, submits that rupees 33,37,622 has been paid. And the remaining balance amount of, no, leaving a balance amount of rupees,
It was 5,32,322 Lordship.
what is? Mr. K. Gogoi further submits that negotiations have been made between the parties, wherein the petitioner has agreed to
20% negotiation.
20% reduction.
Negotiation.
20% reduction.
20%
you mean?
negotiation by deducting the amount.
Has, what have I said? Whereby the petitioner has agreed to deduction of 5%, 20%, 20% from the remaining balance amount payable by the respondent. However, the petitioner would have to submit an undertaking in that regard. Thereafter, the payment of the balance amount would be
Yes,
paid.
it will be submitted.
Thereafter, fresh bill would have to also be submitted by the petitioner for the same, for the balance amount. After negotiations are agreed upon. After the negotiation amount is agreed upon. Mr. L. Mohan, the counsel for the petition, submits that he would like to obtain instruction with regard to the above. Accordingly, leave this matter when after 2 weeks, 3 weeks. When? 2 weeks.
I don't make the instruction the part of the record.
Okay, the instructions received by Mr. K. Gogoi, wide letter dated 25/7/2023, issued by the IGP bracket A, Assam, is made a part of the record and marked as Annexure X. Collectively.
Pleasure. Lordship, here in this matter, Lordship, instruction is awaited as per the Lordship, the petition and affidavit filed by the petitioner, Lordship. Lordship, may I pray for 10 days further time, Lordship?
Mr. You permanent. No.
For my name.
You permanent. Madam counsel for the GMC is granted a further 2 weeks time. To obtain instruction. With regard to whether the amount claimed is an admitted amount. This is the matter.
Let me give another.
Wait, no hurry. Yeah.
Asked if I had taken
Huh?
permission. Submit few of the documents. But Lordship, those documents which I planned have brought to me, those are not relevant with this proceeding, so I'll not file any other documents. Regarding the barring note,
Where is the barring? Where is the barring? Is there some document?
no, Lordship. They have just put a line in that notice, Rakshit. Now,
What notice?
some multiple.
You have to tell me again. I've got no idea what you're talking about.
That is like, the perfect, we were working on that. And they had given us multiple notices that you have not completed the work. Only 8% of the work has been done by you. So in future, we will, cancel the issuance of tender,
Well, issue a?
issuance of further tenders. to us.
Okay, okay. Okay.
Now, let's see. They gave us letters, we replied to them. I have made a part of the reply. Now, look, they are saying that they will cancel the CA,
CA means?
the
Okay.
contract agreement.
Okay, the one you
The work,
present you.
yes, the work. Now, look, the second person.
That they
said
can
that-
do. There's no bar. They can always cancel.
Yes, they can cancel. So, but then, look, we had replied them asking for extension of time. At least give us 3 months extension of time so that we can complete it.
That is again their prerogative.
Again, temporary. Now, look, their thing is that we had completed only 8% of the work. Now, 8% of the work, at least RAR has to be released to us.
I don't know, depending upon.
That is a way of the work done, but not a single RAR was released to us. So there was some monetary constraint also because of the COVID period. So now that means so
This-
they
this-
never gave us the
This
notice.
petition is for what? What is your prayer here?
Of blacklisting us.
Don't mix up the issues. I want to, what is the prayer?
Page number 6.
Okay. It is against the blacklisting. There's nothing against the present contract work. You see, here against the blacklisting or ban.
Yes.
Where is that document? Barring you from participating in some other contract.
But if there is no such document, it is just that whenever
Yes.
we,
Yes, Malas. I'm coming, Malas may come to, in our affidavit, Malas, page 156. Malas, what happened, Malas, earlier in that process, Malas, they, two notice, Malas, may see, in except 56, 156. Here, serial number 5. You are also notified to show for why your firm should not be considered. Please, what? Yes,
What is affidavit of?
4234.
Huh?
In WPC 4234.
Yes.
Affidavit file on 25/4, my lord. File by the, my lord,
156, page 156.
my lord, running.
What is this? Application under for issuance of a writ or offense of a violation of
My lord, they have
barring
modified
the
that.
participation in contracted government. 156, what is that?
My lord, the affidavit, my lord.
The council, please have it paginated, I don't know. This,
No, nowadays, my lord, it is, nowadays, my lord, it is serially, my lord,
I will also not paginated.
affidavit filed by the Rasta number 1 to 4, in,
No, what,
on 25/4.
25?
25/4,
Fine, fine.
filed by Rasta number 1 to 4.
No, you see, Mr. Council, what have you done? You have blacklisted the petitioner or what?
Yes, my lord, one thing is that when, my lord, yes, there is no such order, definite order that for substance such period, European blacklisting. In this affidavit, my lord,
And it's every dog. That is point number 1
1
to
to
4.
4,
Yes, where
my
are?
lord, page last, page, my lord, and except 2 and 3. Two notices, my lord, notice dated 30th of August 2019.
Huh?
Sorry,
30th August 2019.
yes, my lord, para 5, my lord.
Para 5 years.
You are also notified to show cause why your firm should not be considered for non-issue of tender in future for such electrical approach. So again on 18 November 2019, on the next,
Yes, these are the references earlier, well, several notice issued, my lord. Again, in para 5, same, why in future for non-issued tender. Now, my lord, because of their non-fulfilling the criteria and non-completion of the my lord, that work, that is cancelled. That's a different issue. Yes, different issue. Now, my lord, may come to annexure 1, my lord, of the state affidavit. This is a my lord, of whose affidavit? Of the same affidavit, my lord. Same affidavit, annexure 1. Yes. Annexure 1. Yes. There is a my lord, next page, yes. Next page. Yes. This is a part of the my lord, MES military Engineer service manual of contract. Now, my lord, paragraph, yes. This is the action of this abstract, my lord. Action of cancellation of contract, my lord, may come to Roman 2. Once a contract with a contractor has been cancelled due to his continued default in completing the work, no tender shall be issued by the MES formation either to the state contractor or to any of its partners individually or to any of the allied firms till clearance is obtained by the ENCP, Engineer in Chief branch, in exceptional cases. For instance, now, my last fact is that there is a remark by the chief engineer for that of that project that because of that tender, because of that remark, now all the tenders, my lord, they have to apply for electric mode, so e-tender. Now, because of that remark, they are not able to apply for the order. Whose remark? For the engineering ship factory. As per the manual, as per the MES manual, when a party is not able to complete the work,
You see, this
yes,
non-issuance of an NIT
yes.
basically amounts to blacklist.
That is big. One thing is that when I have also go through the document, there is nothing on record that for what period and how such. There is no such specific order.
There is the blacklisting order in the first place.
No, there is no such.
How can you allow?
Only following this manual procedure, my lord, there is a remark from the engineering branch because of the chief engineer's remark.
What does the remark say?
Remark, my lord, when he is default in completing the work, my lord, no tender shall be issued to the MES formation by any MES formation either to the state contractor or any of its partner individual. So this is not have been done by the authority. My lord. I have categorically asked them to provide whether any such specific order regarding blacklist. But that is not. That is then you allow them to. But my lord, that is not. But thing is that my lord, he is saying regarding that my lord, COVID period. My lord, this COVID period starts here from March
That's not
2020.
the issue, you see. The issue is not that. The issue in this writ petition is not with regard to the termination of the contract.
Yes, not.
The only issue is with regard to not being able to participate in other tender.
Our stand is only this specific stand. This is on
Then
this stand, my
that
lord.
stand goes.
Because of that, this remark, they are unable to now.
Which was the contract which was terminated?
Their contract
Page.
in the. Contract agreement of 2018-19.
Huh?
In our affidavit,
In affidavit.
it says that contract is not mentioned, my lord. CWE that PZ plus 859/0.
Page, para
3 of the affidavit.
3. Huh? PZ.
That is the contract, my lord. 2018-19.
Okay, so because of this, now she has been barred from participating in other things. So that's all. Nothing else. Small issue. What is the why is so thick file? I don't understand.
Now, my lord, subsequently they have amended the restriction. They have had mistakes then because other earlier the prayer person was not correct because subsequently so
was written in the.
Huh?
Earlier, in the written, prayer petition was not for.
Prayer for so I had to
Amend it.
something went wrong.
Anyway, that the termination of contract is not an issue here. What is the other writ petition about?
Other petition is regarding non-payment of contractual
Final
bill,
bill.
final bill.
Non-contract, that is a,
No, that is another thing.
that is a different issue.
That is a different separate
This is 986, you mean?
Yes.
986 is with regard to non-payment of final bill.
final bill.
Now, that will, with regard to the same contract work,
No,
different contract work.
Contract was the same, but the works are
Works are
CAs
different.
but then Lordship,
Is-
they were trying to deduct it from that completed. CA
Okay,
to
from the-
recover
my lord,
From this,
cost here.
that they cannot,
This can-
that they cannot. do. How can you do?
my lord, here also we have stated in our affidavit that they have to pay us, my lord, several notices were given. So regarding.
No, no, you cannot take from it.
In our affidavit, my lord, that is the same.
Okay, we will take that separately.
Yeah,
We'll take
separate,
that
separate.
Okay. And let us dispose of this matter.
Got it.
Heard Ms.
And for us.
M. Bora, learned counsel for the petition. Also heard Mr. K. K. Parasar, learned CGC, preparing for all the respondents.
All the,
The grievance of the petitioner is that he has been debarred from participating in any future tenders issued by the respondent, without the respondent issuing any order blacklisting the petition. That's all. The fact of the case is that the petitioner had been awarded a contract. Which contract? Where is that? Have been awarded.
Number TW.
No, where is that? Where is that?
That is
In your writ
one
petition.
forty-eight.
Huh?
148 of their affidavit.
That is contract agreement number. Where is the contract? Where is the, had been awarded a contract, namely CWE / TZ / bracket 859 / 02 bracket close of 2018-19 inverted commas special repair for replacement / upgradation of old vintage transformer and water supply pumps, etc. at various locations under GE bracket 859 bracket close EWS inverted commas close. This is in the synopsis. Okay. So consequently, a contract agreement dated 26/4/2018 was executed between the parties. And the contract work had to be completed by the petitioner on 4/2/2019. In spite of repeated show cause notices issued to the petitioner for completing the contract work in question, the petitioner could not complete the same, and as such, the contract work was cancelled by the respondent on 20/10/2020, after issuing final notices dated 10/12/2019 and 30/9/2020 to the petition. As per clause 54 of IAFW 2249 of the general conditions of contract. This all this up, this pink one, page para 3. Okay. Next paragraph. The petitioner's counsel submit that subsequent to the termination of the petitioner's contract work, as mentioned above, the petitioner has not been allowed to participate in any tender issued by the respondent. He submits that until and unless a debarment slash blacklisting order is issued by the respondent, the petitioner cannot be debarred from participating in the tender process. Huh? Okay, I forgot, I've got a meeting at 1:15. 2 o'clock will continue.
Malo.
Mr. Mitra, I think you should come to the chamber with Mr. R.J. Das. Just now, huh? Yeah, next, right. Just continue, huh? Okay. She accordingly prays that the ban imposed upon the petitioner from participating in the tenders published by the respondent. No. She accordingly submits that a direction should be issued to the respondent to allow the petitioner to participate in all the tenders issued by the respondent. Yes, ma'am. Mr. K.K. Parasa, the learned TGC. Come on. On the other hand, submit that due to the petitioner not
Wait to complete the work.
not having been able to complete the work in the stipulated time frame. The petitioner had been called upon to accelerate the progress of the work, so as to complete it by the stipulated date of completion. He submits that the petitioner was time and again told that time was essence of the contract, and unless the petitioner completed the work within the stipulated time, he was so called as to why the petitioner firm should not be considered for non-issue of tender in future for such lackadaisical approach. Next up, the learned CTC further submits that in terms of
MES manual of contract number 2007. Clause B.
is this section or clause?
Lordship, I have submitted the full thing in my affidavit, Lordship. Page number 175. This portion, MES manual. Contract manual. Annexure 7.
170, your 175 does not match my 175.
Annexure 7, Lord.
Last affidavit filed with him.
On 3/5. we have
One
filed.
75.
Yes, Lord.
Oh, no, no, it doesn't matter.
3/5. 3/5.
Last affidavit filed
3rd May, 3rd of May.
3rd of May, last affidavit.
Page,
Annexure 7.
Annexure 7. Page 175.
you should paginate as per my copy. I should not paginate as per your copy.
Zero.
187. 150. But what is this? Is this section or is this clause? What is this?
Structural section, and these are subsection. The manual is
Right.
not the section.
As per section,
Section 1, that is 1,
as per section 1,
and subsection 1.16.
section 1.1.16, section 1.1.16, bracket G. Is it? G. No.
Yes, 3 months. Next is.
They are reading part, only one part. So you have to read it.
Or section 1.16, G. Bracket G. Huh? G
Within the Roman 2.
bracket small Roman 1. Huh?
Roman
As of the Military Engineering Services Manual of Contract, 2007. As soon as a contract is cancelled on account of a contractor's default, the accepting officer of the contract shall immediately bring the same to the knowledge of the registering authority, who shall examine the case for taking necessary action in terms of the standardized code depending upon the merits of the case. So further, his default shall invariably be brought to the notice of other zonal engineers by a separate letter immediately. This action shall be besides including in the quarterly workload. No. It cannot be one, it shall be two.
2. I said 2 months.
Cut that. It's two. You say G2. Huh?
Once a conflict.
Once a contract with a contractor has been cancelled due to its continued default in completing the work, no tender shall be issued by any military engineering service, either to the contractor or his partners, till clearance is obtained from the engineer-in-chief's branch. He submits that as the petitioner's contract was pertaining to CWE/TEZ bracket 859/02 bracket close of 2018-19 had been terminated due to the continued default on the part of the petitioner, the respondent could refuse issuance of a tender to the petitioner in terms of section 1.16 bracket G bracket Roman 2 of the MES Manual of Contract, 2000. That's all. Smile. I have heard the learned counsel for the fact. Section 1.16 bracket G bracket 2 of the MES manual of contract from 2007 states as follows. That's fine. 167.
But procedure is laid down in appendix 1.7. The cancellation procedure, next page. here. How they can do it.
1.1.
Appendix 1.7.
That is nothing relevant to the facts of the case. Whether it is, you see, we are not on the cancellation of your contract. That is not the issue. Why are you going on a different tangent? The issue is with regard to whether
Whether
you can be barred from participating in other tenders. That's all. Next. A reading of the above section 1.16 G bracket 2 shows that no tender can be issued to a defaulting contractor whose contract has been earlier cancelled. Till clearance is obtained from the engineering chief branch. The letters dated 30/8/2019 and 18/11/2019 issued by the respondent to the petitioner to accelerate the progress on his contract work and to complete the same within the stipulated date of completion. Also, has show cause the petitioner as to why the petitioner should not be considered for non-issuance of tender in future. For such, for the delay completing the contract. Yes, sir. As can be seen from the above fact. No, as can be seen from the submission made by the counsel for the party. The petitioner contract was terminated due to the delay in the due to the petition due to the delay in completing the contract. The subsequent non-issue of tender to the petitioner amounts to blacklisting / debarring the petition from participating in any future tender. Though show cause notices have been submitted to the petitioner with regard to the proposed action for non-issuance of tender in future, no final order to that effect has been made by the respondent. As such, it is quite apparent that the petitioner has been penalized without any final decision, has been blacklisted, without any final decision being taken by the respondent. Disallowing him to participate in any future tender process. That it is taken this in this order, the WPC 496/2023. This is the para 11. Para 11, para 12, Para 14. Yes, sir. Or considering the judgments of the various, considering the various judgments of the Supreme Court with regard to the procedure to be adopted before blacklisting person. Comma. The respondents have to issue a prior show cause notice stating the precise case set up against the person. Specifically making the petitioner know that the penalty of blacklisting / debarment was being proposed to be taken against the petitioner. Besides the above, besides the letters issued by the respondent not being specific enough in terms of the judgments of the Supreme Court, it is also seen that no final decision had been taken by the respondent with regard to blacklisting / debarring the petition from participating in any future tender. In the absence of any final decision being made by the respondents and the same being communicated to the petitioner, the action of the respondents in barring the petitioner from participating in any future tender is arbitrary and in violation of Article 14 of the Constitution of it. In that way of the matter, this court holds that the respondent cannot bar the petitioner from participating in any future tenders due to the reasons stated. The respondents are accordingly directed to ensure that the petitioner is allowed to participate in future tenders unless and until blacklisting / debarment order is made after the procedures required to be followed in terms of the judgments of the Supreme Court are followed. The writ petition is accordingly allowed and dismissed. That is also that. We correct the other one. This one. So, if we elected. Then, this is this. There. This is the. Where is Kalpana? That Kalpana. Okay, put it there. Then in the next case, what is the next case?
Next case,
The release of final bill.
Release
What
of final bill.
completed- Yes, okay. What
Yes,
com-
why not
yes,
final?
Malad may come to our application, Malad.
It'll take some time. We'll take it out again.
Issue is small issue, Malad.
Okay.
Fact is that in the both the cases, issue is regarding the cancellation of that contract. Malad, that contract has been cancelled on 20th of October 2020. In terms of the condition number 54 of general condition of contract,
Actually, it was cancelled when? It was cancelled on 20,
cancelled on 20th of October 2020.
2, 8, 10, 20, write down. The contract was cancelled on 28, 10, 2020.
Earlier. Same. Now, the present contract where they are seeking money, this is of 2017-18. Earlier that cancelled, that is of 18-19.
Now, in that, they have completed, yes, they have completed and raised the bill. Their bill is of, 25 lakh, 65,968. Now, that can, after the cancellation of, that cancel, that reaction amount, they have to pay to the authority, reaction cost.
Risk and cost
Reaction
in this contract, not in the other contract.
No, they, they have to pay reaction cost for
In the other
cancellation
case,
of the other contract, which is,
so you want to deduct that amount.
no, as per the clause 54 of the general condition of contract, on copy I have, that authority, the contractor shall either pay the excess amount ordered by the GE, or the same can be recovered from the contractor by any other means. That, now, that is a huge amount. That is, reason cost amount is 37 lakh something. Their bill is 25 lakh. Because of that, this has been withheld. Because reason cost amount,
Okay, that is the matter of
we have
arbitration.
the,
That's
how,
a matter of arbitration.
this is a government
Because
money.
we have already gone for arbitration.
This is a government money, how can to,
They can recover that for free.
How will they recover it? Supposing the arbitration goes their way, or the award is passed in their favor, how will they? Can you
We
give,
have to pay them first.
then, yeah, for that 25 lakh, can you give bank guarantee?
Okay. If that can be found out.
regarding that, I have to say,
No, if they give bank guarantee, then doesn't take, what is this?
Because this cannot be done that you cut.
You produce a bank guarantee and the next day we release the amount. For this amount.
Because Lordship, this is a separate contract. And we
Whatever
have
it is, since you said you could do it,
there are
you
labor-
submit a bank guarantee for the said amount,
Lordship,
you give that bank guarantee for 6 months.
Lordship, let the arbiter decide that point. Not
That is not the issue, madam. That is not the issue. The issue is they want to secure whatever.
Lordship,
That
if they
might
can
happen.
prove it before the
This
arbitration.
is some other stuff. They are fine. On the present party, this is the matter after a week, after 2 weeks.
It may be fixed, Lordship.
arbitration, that may take some time, because.
Why should it take, arbitration supposed to be completed fast? Yes, please.
Then,
You all push the arbitrator. Arbitration is supposed to be a alternative remedy, a quick alternative remedy. If you all don't want a quick remedy, then of course, that's their problem. So you all push the arbitrator.
after 2 weeks,
After 2 weeks, Lordship.
So. Yes,
Milord, there's section 11 petition, Milord. Milord, when this matter was listed, Milord, before you,
when was the issue, when did the dispute arise?
Milord, it has been arises, Milord, I have invoked the arbitration, Milord,
2017.
2017.
no, Milord, sir.
When
I
the
have
work
refused-
was completed.
Huh?
When the work was completed,
Work was completed when?
2017.
2017 work was completed. Then if work completed 2017, when did you apply section 21? Give me application act.
21, my lord, we applied.
Milord, I have invoked on 21st January 2023, Milord.
21st January 23.
28th January 2023, Milord, I have
28,
invoked the
28.
arbitration.
Then
Milord, sir, I'm coming on that aspect. Final bill has not been prepared. Till date, Milord, final bill has not been
no,
prepared.
that is a different issue. Final bill, if you don't prepare for 50 years, whose problem is
Milord,
that?
Milord, if they have not prepared the final bill until unless I will accept the final bill, the dispute is on, Milord. I am writing continuously later to them. Milord, I am writing continuously later to them. Either final bill, they have finalized the bill, Milord. Milord, the final bill is disputed, Milord. Because what work I have done, Milord,
Page 102, my lord, will take for a moment. The final bill for the work has been signed on 19/11/2018. It was.
Milord, there is a one, Milord, the railway has signed the bill, Milord, it's not a finality. Milord, I have not accepted. Does not mean that, and who has signed it?
Final bill is ready on 19/11/2018.
And my lord, that,
Final bill dated. Yes, Mr. Gupta.
My lord, in the third paragraph three, my lord.
Yes.
In the remarks column, my lord, the third paragraph, the final bill for the work
1911.
has been signed by the deputy CEO on 19/11/2018. The claim of the PVC was raised by us more than 2 years ago. There may be delay on the account of paucity of funds in the project COVID-19. So, the final bill was prepared in the year 2018.
It was prepared by them in 2018.
And the first representation, my lord, which was made by the petitioner, even presuming, my lord, section 21 notice.
This letter 102 is issued by the petitioner.
102 is issued by the petitioner to us. The first representation, my lord, will be at page 100. My lord, the contract was, the work was completed in the year June 2017. And the first communication regarding the dispute, well, even if we don't take the date of the notice under section 21, my lord, that would be
Notice under section 21. Page
page 105.
that my lord, the invocation, my lord, is very, my lord, they can't say that. Limitation starts in the arbitration, my lord. Once they will say, "No, you are not entitled for this money." Not a single letter, my lord, they have issued to me. You are not entitled for this money, you accept the fine, this amount only. Lord, there is no denial.
Page 100 is the first letter communication, my lord, that is dated 11/5/2021.
Neither, my lord, they have released the, my lord, PVC, my lord, neither the security, my lord.
you see, under section 43.
Yes.
I think Limitation Act applies. So if Limitation Act applies, the final bill, whether you accept it or not, was signed on 19/11/2018. 19/11/2018 years will be 19/11/2021.
Yes.
And then you submitted your 21 application in the year 23. Well, beyond limitation.
My lord, I am just coming on that, my lord. If you will see the page 100, my lord, I will just read, my lord, the letter 11/5/2021. We have completed the above work in all respect in the month of June 2023, but still our security deposit and PVC bill have yet not been released by your office. We have already submitted letter for release of security deposit and PVC as the same is pending since last 2 years. My lord, they are sitting on my security, they are sitting on my, and what my lord, they are saying they have already the final bill they have signed by one officer, my lord. And there is a one judgment, my lord, of the Honorable Delhi High Court, my lord, until unless they will denial. Lord, once they will deny, yes, you are not entitled for this amount, Lord. As far as the arbitration matter is concerned, my lord.
You see, Delhi High Court might have said that. Unfortunately, I've got a Supreme Court judgment which says that it will count from the day of section 21.
Lord, but my lord, that dispute, if it is a time bar, that question is going to be decided by the arbitrator. If I am time barred, my lord.
No. You got wrong.
My lord,
Supreme Court said no. Supreme Court can, the arbitrator can do it, but even the court can do it. The High Court can do it.
my lord, I agree with my lord. My lord, the Supreme Court has cleared to either is within limitation or there is an arbitration clause. As far as my lord, in 21, my lord, when we have issued a letter 11 May 2021, my lord, within limitation, my lord.
Yeah, 11 May 21.
Yes.
Is it under 21?
Yes, my lord, what we are saying, it is not under, my lord, we are asking, but they are not, there is no denial of this letter, my lord. There is no denial, my lord.
Let us see the 11/1/21.
Yes, my lord. Our manager so and so in touch with, on telephone with your office, but no positive response was received. Sir, after telephonic talk to our manager, Mr. Rajesh Mitra, had with, we are again sending the calculation of PVC to you to release our security deposit and PVC invoices. Sir, if payment PVC bill takes time, kindly release our security deposit, my lord. My lord, we are asking. And my lord, meanwhile, as we are in urgent need
Mr.
of money-
Council, listen, please, there's no point just, just reading out without applying the law. Section 21 says that unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Now, where is it in your page 100 that you have said that arbitration proceeding should be initiated?
Milord, sir, Milord, because Milord, at that later Milord, we are asking to fill our PVC and the security Milord, which there is no denial. As far as dispute is concerned, Milord, regarding that one PVC Milord. Price variation clause, Milord, they are disputing on Milord. Milord, I am just reading the section 21 Milord. Unless otherwise agreed by the parties, the arbitral proceeding in respect of the particular dispute commence on the date on which the request for that dispute to be referred to the arbitration, Milord. And Milord, after that, Milord,
Where are you reading?
Milord, I am just section 21, Milord.
21 here.
Milord, unless otherwise agreed by the parties, Milord, the arbitral proceeding in respect of a particular dispute
Comments on the date.
on the date on which a request of that for that dispute to be referred to arbitration
Yes.
in receipt by the respondent.
So when did you ask for a request for that dispute to
Milord,
be referred to?
21, Milord, 20.
Yes, when? The date. When did you ask for
That is
the arbitration proceeding?
Milord, we have invoked the arbitration, Milord, in 23, Milord, 21st, 23, Milord. But, Milord, prior to that, Milord, kindly see the letter, Milord, 28 August, Milord, at page 103, Milord.
103.
Yes.
This is of 2022, again beyond.
Yes,
limitation.
yes, Milord, I am coming on the earlier letter also, Milord. Milord, what we have written, Milord. With reference to the above work, kindly refer our various letter during execution of work. And lastly, on 14/1/2020, where it is brought to the notice of department, we are entitled for the payment of various counts. It is submitted that the payment of the following head is pending with the department. The detail are under, Milord. Milord, what detail, Milord, I have already given, Milord. And for this also, Milord, there is no denial on the part of the respondent, Milord. They have not denied, no, you are not entitled for this
Yes,
amount, Milord. Once, Milord,
Gupta,
Milord.
what to do? He has got some issues, some payments have to be made. Because this petition is not made in, it's hit by limitation. That's clear.
What will happen, Malad, what is happening is that by invoking section 11, the time barred claims are being adjudicated by the arbitrator. That is impermissible. And Malad, even if we presume the date of his first letter, Malad, page 100, therein categorically the petitioner is stating that Malad, the works we have completed the work in June 2017. And Malad, the letter is dated, Malad, 11/5/2021. So even from June 2017, if we count 3 years, Malad, that is over, Malad, by June 2020 itself. June 2017, if Malad will count 3 years from there, it is getting over by Malad, June 2020.
Milord, work has been completed. What about the payment, Milord? There is a denial, Milord. Either they have denied, Milord. 21, Milord, I am writing a letter, Milord, where there is a denial.
Mr.
You are
Counsel,
not entitled for this amount, Milord.
I'm-
Once there is a denial, Milord, only then the limitation is start, Milord. From that, the limitation is going to be a start, Milord.
Even if I take, Malad, the section 20, even if I am not taking that section 21, okay. So even if I presume from the cause of action, Malad, that is when they raised the issue first, that is also, Malad, beyond pay. That is 2021.
They did not come prior to that.
Yes.
Milord, Milord, the 3 years, Milord, only denial, Milord. In arbitration, Milord, once they will deny it. You are not entitled for this amount, Milord. Milord, which they have not done it, Milord. Milord, I will place one judgment, Milord, of the Supreme Court itself, Milord, on this aspect, Milord. Until unless, Milord, right now, Milord, I am not available.
Right now,
If-
right now, you don't have it, problem is I have it. I can't wait for you.
But the issue has been decided, not as.
It's a decided case, I know, recently also. It comments from section 21.
2023 also, Malad, 2023 SCC online 657.
Yeah, yes, where is it?
E and eligibility relevant issue is at paragraph 53. The issue before the court, Malad, the two positions which fell for consideration.
Paragraph 51,
Paragraph
52. No, Mr. Council.
No.
51, 52, then it jumps to 59. The relevant pages are not here. Fifty-one, 52. Oh, it's here. You have put it wrong. Okay, okay. You have put 50, 51, 52, 53, 54. Then it jumps to 50, 51 again. Okay. So, just a minute, 58. So this is extra. This is cost contribution.
Yes.
53.
53, Malad. The following two questions fell for consideration of this court. The period of limitation for filing an application in the section 11 of the 1996 and whether the court may decline to make reference under section 11 when the claims are exercise time barred. The court, this court observed that the Act 96 has been framed for expeditious resolution of disputes and various provisions have been incorporated in the Act of 96 to ensure that the arbitral proceedings are conducted in time-bound manner. The 96 Act does not prescribe any time for period for filing an application in 11(6). Since there is no provision in 1996 Act specifying the period of limitation for filing an application in section 11, one would have to take recourse to the Act of 1963 as per section 43 of the Act 96, which provides that the limitation shall apply to arbitrators as it applies to proceedings in the court. Since none of the articles in the Schedule 2 limitation provide a time period for filing an application for appointment of arbitrator under section 11, it would be covered by the residual provision under Article 137 of the Limitation Act, which provides that the period of limitation is 3 years for any other application for which no period of limitation is provided elsewhere in the degree. The time limit starts from the period when the right to apply accrues. Not here, when the contract work was completed in the year 2017, within a period of 3 years, Malad, they should have.
Or from the date the final bill was passed.
But finally, the only thing take place once they will signed by both the parties, Lord. They will just
No,
prepare the
no,
Lord
no,
final
no,
bill and
sorry. You see,
Lord-
final bill, it can start from the date the authorities have, because they'll be at a later
Lord-
stage.
Yeah.
When they have approved a final bill, whether you agree to it or not, that's a different issue.
that is the dispute, my Lord. Lord, that is the dispute, my Lord.
Correct, that is the date when it will accrue.
Below-
Supposing it accrues from that date.
Yes.
From the date that the final bill has been passed by the authorities,
Below-
which you do not agree to. It'll be, but if you say that it should start from the day you agree, then you could have agreed prior to that.
Yes.
Okay.
Lord,
So
I'm
that
just-
will be based on.
Just, my Lord, what they are saying, my Lord, the final bill was
Okay,
prepared
right. I've heard. Yes, Molly.
because on 19 onwards, my Lord, I am writing a letter, my Lord, continuously. If you see the page, 100, my Lord, I am
Well, what about you give him the admitted amount, whatever? Is there any admitted amount? But this is not a writ petition. This is an article, this is a.
Yes, my Lord, this is section 11. Section 11.
I cannot go into those.
My Lord, I-
This is a section 11 petition. Section 11 petition. I cannot
Lord-
mold the relief as I want. I am bound by the four corners of the
Definitely.
provision of 11(6), 21 and 43.
Lord, but Lord, it's all like what my learned friend has pointed out, Lord. Final bill has been prepared. They have not a single denial, Lord. Till date, Lord, they are not saying, Lord.
Then,
Once I have filed-
then there is an appropriate forum. Then you see, this is for appointment of an arbitrator. This is not for regarding whether your final bill is correct or not. This is a different, the issue raised in this petition.
Yes.
Is under 11(6). It is not with regard to
Lord,
whether
that's why, Lord,
you should be given the final
Lord,
bill
if-
as made by them or not.
Lord, if it is my claim is time barred, Lord, what my learned friend is pointing out, Lord. That is also,
Your
Sir-
claim, and you see, it is not, he's pointing
Lord,
out only what the Supreme Court has
16 is
said.
there, my lord. If my claim is time bar, my lord, then arbitrator can dismiss it, my lord. My SOP, my lord.
But Supreme Court has said that we should dismiss it.
My lord, the judgment I have stated out, my lord, last paragraph, it was dismissed, my lord, section 11 application.
Ah,
Paragraph 80, the case on hand is clearly and undoubtedly one of a hopelessly barred claim, as the petitioner by its conduct slept over its
Correct,
right
correct.
for
no, we can
Whatever
dismiss it. Actually,
by-
you have not read I read it somewhere that the High Court should look into it and should dismiss it.
Differently, my lord. I'm not saying that the judgment is very clear, my lord. Limitation is going to be looked into. My lord, the limitation when a start, my lord, that is also a point, my lord. That when it is going to be a start, my lord. It is only going to be a start, my lord, once there is a denial, my lord. And there is no denial on the part of the railway, my lord.
Supreme Court has said, not Supreme Court, Section 21 says, date of limitation will start from the date the respondent receives a request for appointment of an arbitrator. That's all. Nothing else. That is the law, Mr. Counsel. There's a puny High Court judge. I cannot change the law made by the government. Yes, I can. Right. Heard, Mr. F. Hassan, learned counsel for the petition. Also heard Mr. H. Gupta, learned CG. This is an application under section 11(6) of the Arbitration and Conciliation Act, 1996. Hereinafter referred to as the Arbitration Act, for appointment of an arbitrator in terms of the arbitration clause provided in the contract agreement dated 20/07/2010, executed between J. Sons Company Limited and the railway. The petitioner's counsel submits that where is the arbitration clause?
Page, my lord.
Page
58, my lord. Type of it, there, my lord. Clause, reconciliation of dispute, my lord. Clause 63.
19 is the
19 is a type.
19.
19.
Submits that as per clause 15.0 of the
This is the contract agreement.
contract agreement executed between the parties, arbitration and settlement of dispute is to be governed in terms of clause 63, and 64, 63 and 64
Yes.
of the
63 and
general
64 of the-
conditions of contract, NF Railway, 1998, edition. This is a general conditions of contract. First,
Let's say GCC, the general condition of contract.
he submits that the petitioner had completed the contract work in all respects in the month of June 2017. However, the security deposit and PVC bills have not been released by the respondent, despite submitting letters of release for the same by the petitioner. The petitioner's counsel submits that the petitioner had submitted a letter dated 11/5/21 for release of the security deposit and PVC bill. And as the same was not being acted upon by the respondent, the petitioner the petitioner submitted. Where is the 21 application? Huh?
Here's 105.
Submitted. Letter dated 28/1/23 to the respondents to, invoking the arbitration clause provided in the contract agreement for appointment of an arbitrator. Next. The petitioner's counsel further submits that in terms of the petitioner's letter dated 14/1/2021 or 22, what is this, page 102? 14/1/22, comma. The final bill for the contract work has been signed by the Deputy Chief Engineer /CON/SPTR on 19/11/2018. Which is not accepted by the petitioner, correct? It is not accepted. Good stuff. Next. Mr. H. Gupta, the learned counsel for the learned CGC, appearing for all the respondents, submit that the present application under section 11(6) of the Arbitration Act is time barred in terms of section 21 and 43, bracket 1, 43(1). Forty-one. 43, what is the 43? 43, two also, 1 and 2.
1 and 2.
43, 1 and 2. 1 bracket and then 2, Roman 2. No, small 2. Again, within bracket of the arbitration. He accordingly submit that the arbitration petition should be dismissed in terms of the judgment of the Supreme Court in the case of B&T AG versus Ministry of Defense, reported in 2023 SCC online. Don't say reported in, just say 2023 SCC online SC 653. Okay. I have heard the learned counsel for the part. Section 21 and section 43 of the Arbitration Act states as follows. As can be seen from a reading of section 21 of the Arbitration Act, arbitral proceedings, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute is to be referred to arbitration. To be referred to arbitration is received by the respondent. Unless otherwise agreed upon by the party. I know, I'm one at a time. I'm in 21 only. Good stuff. The above, in the present case, the letters issued by the petitioner dated 11/5/21, 14/1/22 and 28/1/23 show that the contract work had been completed in all respects in June 2017. The petitioner, in his letter dated 14/1/22, had stated that the final bill of the work had been signed by the Deputy Chief Engineer /CON /SPTR on 19/11/2018. However, the petitioner submitted his letter and has written a letter to the respondent for appointment of an arbitrator only on 28/1/23, that is beyond the period of 3 years from the date of completion of the contract and also the date of signing the final bid for the work by the Deputy Chief Engineer. In section 43, 1 and 2 states that the Limitation Act 1963 shall apply to arbitration as it applies to proceedings in court. Section 43 bracket 2, not 43 1, The 43 bracket 2 states that for the purposes of section 42 and the Limitation Act, 1963,
Point out one thing.
an arbitration shall be deemed to have commenced on the date referred in section 21.
Look, if you will see the later date is 23rd August 2022, my lord.
3rd August
Yes,
22.
page 104. Lord, if you will see the last line, my lord, it is a notice as per clause 63 of the act. My lord, here also in 22nd August 22nd, 22, my lord, we have talked about the three, my lord, it's all right, my lord, after that, because there is a provision, my lord, in railway, my lord, we are supposed to be nominate one man from our side and the one man from the railway side, my lord, that's why, my lord, in vocation, my lord.
Yes, Mr. Counsel, you see, one thing. Contract work was concluded in 2017.
I agree.
So this letter does not cover that. Now the second portion. Final bill was made on 19 November 2018. That means 19 November 2021 is the date. Now this letter is of
Lord,
August
Lord,
22.
Lord, I'm just coming. Either the railway has informed about that, if they have already prepared the final bill, come and sign it, my lord. They can show me any.
This is
document,
your
my lord.
letter. This is your
My
letter.
lord, all right, my lord, they have informed me, my lord, but they have
Dismiss.
not.
Next. Dismiss. Dismiss.
Item 28, my lord, we have received instruction regarding submission of report. We may be allowed a week's time to file an affidavit.
Item
to
28.
Bring it on record, my 28. It is
Mr. Madam, this was April 24. Since then, 2 dates have gone by.
29/4/24, my lord, and order.
29/4/24, then 13/5/24, then 22/5/24.
We received this instruction today. my
Okay, you have
lord,
received
so
instruction.
we-
Oh. Good. Okay, you have received instruction.
Yes, sir.
To what
Please
effect?
that before your lordship.
Okay.
My lord, in the third page, last paragraph, an arrangement was proposed wherein
Just a
the
minute. Last page, third paragraph.
third page.
Third
and
page, last paragraph.
last-
Yes.
An arrangement was proposed wherein the petitioners would have been accommodated in the market complex in the first floor and the second floor due to the non-availability of visas in the ground floor, which had already been allotted previously, but the petitioners were adamant to get allotment only in the ground floor, for which the matter could not be amicably settled.
You cannot have you cannot have everything that you want. They're giving you a first floor and second floor. You see, you want space in the market. They're giving you space in the first floor and second. What is your right that you should have it in the ground floor?
For my, it's not number two, minus page 1, 13 numbers. They were already allotted.
Naturally, that time there was all bamboo sheds. Everyone was in the ground floor. Everyone was in the ground. No one, there could not be any vista and, huh?
New at present.
What?
The 13 numbers of it who already allotted. We are allotted minor because new complex minor is down. So we are the minor original allotted. And we are also minor the idea okay then we file the
Okay, you file an affidavit.
My lord, I'll file an affidavit.
Miss
You, Sharma, LSU,
U. Sharma appearing for
for all the respondents.
all the respondents submit that she has received instructions and would like to file the same in the form of an affidavit. Prayers allowed, list the matter after 2 weeks.
till the minor target.
Is there any interim order?
The lot to go. 29 order, RBI interim order minor 13.
Okay, interim order passed only, it continue to be.
Applied.
I do agree.
29.
My lord, it's a third position, but GMC has taken like 5-year experience.
About 5 years allowed, my lord.
Huh?
About more time may be allowed after 2 weeks. Which is
As Bora left hospital, GMC is granted a further 2 weeks time. So, ten instructions, take the matter for 2 weeks.
Actually, a date may be fixed, my lord, the MSCP may have contact us, my lord.
What is the matter about?
Non-payment of
on payment of thing.
a date, my lord, after 2 weeks. Deeply obliged.
Yes, what is your case?
Look, it is against me the order of awarding contract to the private.
Private respondent, the affidavit for the private respondent is not available to the private respondent number is 6.
So? What? So? You could not obtain instruction after filing affidavit. What? You're having a standing committee there. Tell us what you're discussing. Okay, you can proceed. So have you received the affidavit?
Yes, my lord, I have received.
Yes, what is your case?
Milord, Milord, in this case, Milord, I have to basically 3 grounds, Milord. First ground, Milord, they have changed the rule after the game started, Milord. And secondly, Milord, the
Against what rule?
Milord, yes, that is Milord, at page 28. At page 28, Milord,
Page 28.
28.
Yes.
That is Milord, the online bid opening date.
Online bid opening date.
That Milord. Because Milord, there were 2 bids, one technical, another price. So when Milord, this column is given online bid opening date, that includes both Milord.
Ah.
That was on 7/7/2023, Milord.
Yes.
Now, Milord, kindly come to page 97, Milord.
Yes.
Milord, this is the Milord technical bid, Milord. Whereby I have also qualified and the
private respondent also qualified, my lord, along with, my lord, 5 others. And in the bottom line, my lord, price bid opening date and time September 7, 2023. my lord.
Price bid on,
That
Seven.
last line, my
Yes.
lord.
yes, so,
So, my lord, in the NIT, it was on the same day, my lord.
so how does it cause you prejudice if it has been changed?
Yes, my lord, because, my lord, there was a gap and they did not disclose the marks obtained by me in technical weeks, my lord.
When was technical bid was, acha, technical bid was opened when? On 7/7,
4/9/2023, my lord.
4/9?
4/9/23, my lord. Page 97.
It says 7/9. Where is 4/9? Where is it is 4/9?
4/9, my lord. This is technical bid was opened, my lord.
Okay, 4/9, yes.
4/9. And in that document, it was mentioned that, my lord, price bid will be opened on a later date, my lord. That last line, my lord, on
On 7/9.
7/9. But it was not opened on 7/9. My lord, kindly come to page 98, next page, my lord.
Yes.
That was opened on, my lord, 22/9/2023, my lord.
Yes.
After a gap of 18 days. And if your lordship comes to the entry 1, that is the private respondent, he obtained mark 95, my lord.
Yes.
This is too high, my lord. So, because of 18 days gap, my lord, 18 days gap, there was a scope for manipulation of the mark. And we have filed a representation to disclose those marks. Because, my lord, at page, my lord, page 38, my lord. Page 38. This is the parameter, my lord. And there is a 6 headings against which mark was to be awarded. So, my lord, we have filed representation under what heading?
Under RTI.
No, my lord, by filing representation.
File under RTI. We cannot, High Court cannot be used for RTI purposes.
But my representation, they have to consider, my lord.
No, that's why you file RTI. There is no, it doesn't mean that just because you write a love letter to someone has to reply to you. Where is that? That every time you file a representation, they have to reply where? Supposing I write a letter to the president of USA, does he have to reply to me? Where does it say that?
Because they have to maintain transparency, my lord.
That's why you please use the RTI Act. It is an act, statutory requirement is there. You cannot use the High Court for your as a post office for gathering information. There's an RTI Act 2008. Apply that. Within 1 month, they'll give you SPI. If not given, you go to the next authority within 1 month. Otherwise, you go to the commission.
However, they have to act as per the NIT, what they have given the impression to us. They have to act according to that.
How? First, you have got to show what prejudice is caused to you. What prejudice is caused to you?
Because I have made,
What right of yours is violated if they do not do something in a particular day?
because that gives the scope to manipulate the marks, my lord.
Was it manipulated? Was it manipulated? Right now, you have got no case. You're trying to make a case. You say that it gives a scope. Agreed. There is a scope for manipulation. But supposing it is not manipulated, then what happens? Why didn't you make that? RTI application. Yes, Ms. Gan.
I have another.
He basically he's saying that he wants to know how this person got so many marks.
My God, regarding the allegation was that there is a no transparency within the mark regarding the bid
So
procedure.
you bring the marks at the end of the matter.
Yes, kindly see 139, page number 130.
139.
Yes, ma'am. After the entire document clause is affidavit in opposition. 18, process to be contained information relating the exercise of evaluation and conclusion tender and the award contest will not be disclosed to the tender or other person not officially contact which has the role until the award of the tender has been.
So has the award of the tender been announced?
Yeah.
If it has been announced, so this the confidentiality clause is gone now.
Yes,
Then why don't you provide? You can provide. End of the matter.
Yeah.
That's all you want.
No, the other part, my lord, I have another ground. The financial bid
Ah.
Submitted by the respondent,
Ah.
that is, my lord, that is a void one. My lord.
Why?
Because
Why?
that was not in consonance of the daily minimum wages act. My lord.
Minimum wage is that.
Yes. And there was also a clause, my lord, in the,
Now tell me one thing. Was you are a valid tender or?
yes, I'm saying that I'm very, and they are, yes.
And is it your case that that the respondent number, what's the respondent number? The selected tender 5. If respondent number 5 does not get the tender, he should not be awarded the tender. That's it. Then who will get the tender? Who should be selected?
Ultimately, according to me, I am the very best.
But you are H5. You are not H2.
Yes, it's fine, but my lord, prior to that, they have to comply with the,
No. First you tell me.
my lord.
You have got to prove
Below.
the award of tender to H1 is
Invalid.
invalid.
Yeah.
Number 2, why should not H2 get the tender?
No, my lord,
Have you made any allegation against H2?
none of the qualified tenderer have, my lord, filed a valid tender, my lord.
Have you made H2 a party here?
No, my lord,
Have you made H3 a party here?
no, my lord.
Have you made H4 a party here? No.
They have waived their, my lord, right,
No. You are challenging
my lord.
the selection process. In terms of the selection process, if H1 does not get the tender, H2 will get the tender. Have you made them a party because their rights are going to be prejudiced? Have you made H2 a party? Have you made H3 a party? H4 a party?
I have not met, my lord, but they haven't come, my lord.
That's not it's your writ petition, not their writ petition, Mr. Counsel. Where is the question of they coming?
So they have left their rights,
They have
whatever.
not left. They have not left. They have said that they're happy with H1 getting. But once H1 is cancelled, H1's tender is cancelled, election is cancelled, then their rights come into play immediately, automatically it comes. They have not.
In that case, my lord, I shall make them party, no
You
problem.
make a party if you want. But more than that, what is your right? I don't know. I do not know what right of yours has been violated.
So that is, my lord, that non-compliance with the, my lord,
Minimum Wages Act.
minimum wage.
Where does it say in the NIT that Minimum Wages Act has to
Yes,
be
yes,
complied?
my lord, yes. Not only minimum, other acts also, they are, my lord. 44.
Page 44. Yes.
The 12, my lord, Law
Yes.
Act Executive Body. The
Yes.
agency shall be solely responsible for the compliance of the provisions of various labor and industrial law relating to wages, allowance, compensation, pension.
Now tell me, how will the respondent number 5 bid not in consonance with this?
That is, my lord, page 12, my lord, is my petition. But prior to that,
Mr. Council, you see, allegations are fine.
Yes.
Averments are fine.
Yes.
But they have to be supported by documents.
Yes, documents, I'm showing you. I'm sorry. Because in the NIC, they have not specifically said that how many persons are required for the hospital. No specific number.
Now, you took part in the selection process.
Yes, sir.
Can you challenge now the method of selection or the terms of the tender?
No, because
Then?
what has happened, they have not said, but they have given certain parameters. To ascertain
Show me where, show me.
Yes. at page 34, because at page 34,
Yes, page 34, yes.
without that bold portion, because
Yes,
the housekeepers will be posted in 3 shifts.
yes,
Per requirement of aims.
yes,
So
yes.
the number of manpower to be deployed shall be as per national guidelines for Green Hospital, Kayakal for hospital, so and so, indicator of the CCTC. Now, with the close A, ward, minimum sanitary attendant per ward in each shift for the white ward size up to 30 beds. If more than 30 beds, then one additional sanitary attendant may be provided in the mornings. Operation theater method, like this. So many clauses are there.
So how does this violate, how do you connect this page 44 with this page 34? How do you say that
Without
the tender of the respondent number 5 is,
calculation.
Huh?
As per this calculation, one has to provide at least 680 outfits.
so? So how much has he provided? How much did he say that he will provide? With point number 5.
If your lordship go to my that page 15, I have given a calculation as per those documents.
I think you're forgetting that you're a tenderer, not the author of the tender foundation. No page besides that. Oh, you want information, you get the information, that's all. Then after you get the information, then you can challenge. But right now there's nothing. Without having information, basically you're straight away saying that he's violated this. How is it possible?
Because they have given certain parameters.
But you said that you don't have information.
Regarding what? Regarding without personal requirement of personal method. That can be inferred without.
Inferred.
Yes. Because of their parameter, from their parameters.
Yes. Yes, anything.
That is his own, evaluation that regarding the parameter. That is the
He cannot challenge the process.
Yes.
That is the division bench judgment is it. Only thing is that you can be given is your information, you get the information first, then if you find from the information that something is wrong, then you challenge. Inference is not, where is the question of inference right now? Where is the admission by them of your inference?
From those documents they have that from their document itself.
But you said that you don't have the documents, you don't have any information.
Regarding number of personal requests that I have raised 2 grounds without.
Okay, what are the 2 grounds?
That one is that without they have not complied with the NIT without, because NIT gives the same date.
I mean, they have changed the date of opening. That
Yes.
is one.
Yes.
Change date of opening. Then number 2,
Keeping acting days gap in between financial bid and this technical bid without. Keeping a scope for manipulation. Second,
is there any citation in support that they cannot change the date of opening? Have you got any rulings which says that date of opening of a technical bid or a financial bid cannot be changed.
Right now, I do not have.
You do not have. Then according to your law, it's not permitted.
In my submission, because
No, your submission as per what? Your submission has to be based on some law.
because you know, looking for judgments, it is fair, it's transparent, we don't.
Correct. That's why you have got to.
Applying those law, we don't itself.
No, no. Not that. You have got to show.
What was the reason they have not said that as to why they have kept the.
Okay, we'll ask them to file affidavit. If have you filed affidavit?
That,
And what have you said? Why have you changed the date? Why have you changed the date of opening?
At the time, December 126.
Yes,
Second set of.
yes.
Based on report of technical risk committee, 5 out of 7 leaders were declared technically qualified. Accordingly, the financial needs of all 5 technical qualified leaders were broken for further equivalent ranking of as per Rule 160 of Federal Financial Rules. Department of Executive Finance, after intimating the date and time of opening the financial to all already informed by the regulation of ranking was done the commission for the state purpose and procedure has been.
Madam.
Yes.
You see, what he's saying is that certain dates were given for opening of the financial bid and the technical bid.
Yes.
You did not open it on that day. Why? Why did you, what was the reason for the change in the date? What is the explanation? So just explain that.
Yes.
So where is the explanation? On the prayer of Mr. Gam, that it is to submit a shall file an additional affidavit. This is the matter. After.
Below the, in that affidavit, they will disclose the marks below, they can, there is nothing.
You disclose the information. What is it?
Despite the death of 16, they have not filed the affidavit as nor
Okay, right. Mr. Ara Goyal has counsel for the PC department is granted a further 2 weeks time to file affidavit. Who's the matter?
they are free. They are free for this.
Huh?
This.
It's a new case, madam. It's just 2024 matter. After also same.
Finance.
Huh?
Finance, but I think it's the finance.
That is according to them if they want to impeach. Why not impleting?
On my oral prayer, your lordship.
Oral prayer does not, there's a notification issued by the High Court that by orally, those things cannot be done anymore. Because in the CIS, it does not get uploaded.
I'll find that today.
Yes, you find it.
Obliged.
Where's the conflict?
Before submission, Larnet and Larnet Council expiring 40 days.
Huh?
Larnet Council expiring for the writ petitioner, Mr. His father was ill from Saturday last. So he left for Gwalbara from Guwahati on Saturday, and he was at Gwalbara on Saturday and Sunday. Today morning he came from Gwalbara to Guwahati due to his father ill, almost 18 years old. So it was told to my senior tomorrow morning, and he told me don't mention it at 10:30, but you say that at the time of calling for diet. So if Lordship gives another date, he should give.
No,
He was here, but he could not prepare, Lordship. He could not
he
prepare.
could not, there's nothing to prepare, but anyway.
Only the Lordship.
I know, which is the clause? 30,
He will
30.
take up on Thursday, Lordship.
We will, don't know. Let me get the hang of it again. 30. 30 is okay.
The tender bid,
Huh?
there is a clause that bidder has to look the fishery before going to the, in the particular lot.
Physical structure of the Meen Mahal. I know that this physical cannot be physical structure. Must be the physical, there must be the boundary. Yeah. I think this translation is not correct. But anyway. Uh, Yes,
In the tender bid,
the translation is like this. Since the second party has shown interest for taking the Meen Mahal on lease after examining the total area, physical structure of the Meen Mahal and making spot verification of the same, it must be after any application filed by him to the first party in the event of facing loss will not be entertained by the first. That's the one.
that is it, that is in the tender bid also, here side,
In the tender,
in the tender bid also,
where page,
here in the tender document, where you.
tender, page.
No, no,
Acha, is there?
it is in the record. Same clause, what is. That's in the particular. Particular, same.
Can you give this section, I mean, this clause 30 for this vernacular?
Particular lot. I will translate it. Just now I got it.
For me, if you say this is Telugu or Tamil, Kannada,
Then this.
I will agree
That
because
same-
I don't
same clause is
understand the
in
word.
Same
Huh?
clause, same clause in place.
No, but is the wording the same? Same to same? Is it same to same? Can you just translate this?
Same.
No, I want this translation. I don't like it. It's not very good. The office translation. Just translate this. Which clause is this?
This 6.2.
6.2. 6.2 of the tender notice
Yes.
of the NIT.
And I, where he has signed.
Yes, sir. Okay. Very yes, sir.
No,
Oh, he's here.
I have. These things in the. I have talked to them at morning from my.
No, he said that he had left.
No, I'm not. I'm not thinking. Morning from Palapa.
Okay.
I'm not there and he was in. Day after tomorrow or tomorrow waiting. That's why I said.
Ah.
Anyway, but I think you're.
There's nothing left to decide. I only wanted this translation for my benefit. You all have got nothing to argue left. Everything was heard.
10 plus. I can.
You just show him where he signed.
While filing the tender, we just signed. He has undertaken that he will not claim anything from us. If it is, this clause is there, I have nothing to say, Mara.
You have got nothing to say.
Yes.
Okay, right. Para 10. Huh? Para 10. The official records have been brought before this court, and a perusal of the same shows that the petitioner had signed an agreement with the respondent for running the fishery. Clause 30 of the agreement states that the successful tenderer as the successful tenderer has shown interest in taking the fishery on lease after examining the total area and the boundary of the mean mahal, after making spot verification of the same, comma, any application filed by him to the respondent in the event of facing loss under any circumstances will not be entertained by the respondent. Full stop. The said clause in the agreement has also been inserted in the terms and conditions of the re-tender notice dated 14/2022, correct? Re-tender notice 14/2022 at clause number
6.2
6.22
of the technical bit.
of the technical, of the technical bit, of the bid, is it the same bid, 14 of 2022 dated 19/9/22? Huh? That's a re-tender notice dated, the re-tender notice number 14/2022 dated 19/9/22. Huh? The said re-tender notice and the terms and conditions thereto have also been accepted by the petitioner by putting his signature on the same. Full stop. In view of the terms and conditions provided in the tender notice, re-tender notice, and the agreement, which is known to the petitioner, comma, this court does not find any ground to interfere with the impugned order dated 14/7/2023 issued by the respondent number 2, cancelling the settlement of the fishery with the petitioner. Consequently, the writ petition is dismissed.
The amount deposited by his matter.
You're a defaulter.
I
do not know.
Some deposited, some interest.
Yes.
Amount.
Has to go to the civil court.
Huh?
Investment. Investment has to.
Yeah, investment is a different issue.
There any issue regarding any investment cost?
No. Just a minute. In the event the petitioner is entitled to receive any dues from the respondent, from the state respondent, as per law, the same may be. The same may be given to. I have not talked about interest. The interim order passed earlier stands vacated.
Time, but because in the last location, I have lost time from your lordship.
You have taken a lot of time.
Because the lady is a widow and she has not been able to communicate with the office as well as with me. She has communicated with me over phone and she doesn't understand what I spoken. I also doesn't able to understand. That's the last time.
This is only with regard to leave encashment, nothing remains.
As per her, she has talked with me over telephonic conversation. She told me that she was supposed to get some amount from the department.
Under what provision?
How much amount she also doesn't know. That is the main problem.
But has she got any communication from the department or from some government, from some person? Has she got any communication that she's going to receive this much amount of leave encashment or something like that?
Yes, but that is what I have.
Ask her to send you by WhatsApp photo Then,
last means I am,
okay, right, on the prayer for adjournment made by Mr. Arun Das. Arun Das, then
Ar-
counsel for, huh?
I am the.
RM Das, then counsel for the petition.
Lordship,
What to do?
Lordship, till now, we do not have any information whether they have supplied the details that required by the provident fund.
The only issue now is with regard to leave encashment, I think. Or what, is there something else?
Provident fund.
Provision fund.
They have, the Provident Fund Commissioner wrote to us stating to keep the
Detail.
detail. Till now, there is no communication either from the Provident Fund Commissioner or from their side that they have supplied.
Okay, right, from the prayer made by Mr. RM Das. And then counsel for the petitioner who submit that he has not received any positive communication from his client. This is the matter after 2 weeks, after 3 weeks. This is the matter after vacation. So, Mr. B. Chowdhury appears for the respondent and submit that no communication has been forthcoming from the Provident Fund Commissioner and from the petitioner with regard to payment of Provident Fund and lead encashment of the petitioner. This is the matter after the verification. I can't hear you. Because the mic is there, we are here.
Submission is already completed.
So, what is to be done?
Correct.
Admit it. What is the content?
Violation of order dated 18, sorry, 13/8 of 2018, passed in
Page
170.
So the title suit 1 of 17 was to be disposed of. So has that been disposed of?
Not 20 of 2011.
20 of 2011 was renumbered, I think.
No, no.
Huh?
1 of 2017 is it.
Huh?
20 of 2011 is a original.
Correct. But that 2011 has been renumbered.
1 of 2017. Again, it has come to the original code, carrying number TS 20 of 2011.
Okay, come back. So has it been disposed of?
No,
So so why is it not disposed of?
because I filed a petition method in 98 of 2023, wherein I prayed for a judicial inquiry or inquiry by a commissioner whether the land as directed to be restored by the restored, as directed to restore by the Honorable High Court in writ April 167 of 1999, it can be restored or not. So this is an imaginary land, non-existing, unidentifiable.
I'm not getting you. Ah, this ex parte order area 23/12/2005 is passed where? In which case?
In irritable number 17 of 1999. The respondent number 9, 10, and 11, when they initially writ petition, that was rejected, and the petitioner relegated to the remedy of civil court. They, instead of going to civil court, they have filed and writ appeal.
Who filed it appeal? The petitioner.
Respondent number 9, 10, 11. Five respondent.
Writ appeal allowed, writ petition allowed.
Writ petition rejected.
If it rejected, why did the respondents go in appeal? What was the reason for respondents to go in appeal if writ petition is rejected? I am not understanding. If writ petition is rejected, it is the writ petitioner who should go in appeal. Why should the respondents go in appeal? They have won the case.
Writ petitioner was the respondent number 9, 10, 11. Writ petition.
The respondents number 9, 10, 11 here in this contempt. Okay. The respondents number 9, 10, and 11 were the writ petitioner.
Yes.
WPC number
2407 of 1999
2407 of 1999 regarding
regarding
land.
land.
Regarding land.
In
And
note, it is been noted that they file in respect of their land bearing tag number 295 in PP number 2.
so the respondents number 9, 10, 11.
Right.
They were the writ petitioners. And what were you in that writ petition?
Writ petition I have responded.
Responded. So writ petition dismissed. They filed writ appeal.
Writ appeal.
What did the writ court do? What did the appellate court do?
Division bench of this cycle.
What did it do? What did it say? Has it been disposed of? I think we are going to take a long time. No, I want to know what is going on. I'm not understanding okay. So,
By the writ appeal 167
WA number
167 of 1999.
167 of 99.
Alleging that I have enforced their court of land.
Okay. So what happened? What did the court do? Appeal allowed.
Initially entertained the writ appeal and initially passed an ex parte interim order with conjunction is and may. That is purely hypothetical. Thereafter,
Then what happened? So you went to Supreme Court.
no, my lord. Then I filed because I was anxious with the repeated incidents of trespass. I filed a writ petition in my land bearing tag number, separate tag number 293 and PP number 11. This is my right number.
Tab number 293.
PP number 1130. This is the separate
1133.
1130.
WPC number
WPC number 6991 of 2003.
6991 of 2003.
Yes, sir.
Now, what was the
For
appraisal?
protection of my property and life. Because with the status quo order, interim status quo order, they started with criminal.
Protection of life and liberty.
Yes, sir.
So,
Life and property.
so then what happened?
Then in the motion itself, the honorable court,
Horrible court.
honorable,
Oh, honorable. I thought you said horrible.
honorable Red Court directed the deputy commissioner to demarcate my land bearing tag number 293 of CP number 1130. And directed to allow me to reconstruct my boundary fencing and also to give protection, police protection.
Okay, then, so demarcation done
Demarcation done,
in your favor?
yes, fine.
So in your land, there is a,
In my land,
in your hand, there is a house.
yes, fine.
There is
Thereafter I, constructed.
You are residing in the house.
Yes.
Then you constructed a thing. You constructed a wall boundary.
Contour.
Now what is the problem?
Then thereafter, they put an allegation, one allegation that I have trespassed into the land in coalition with the Deputy Commissioner in Sukia and towards the piece of land that is given, described there
So they filed which case?
in the this case, in the 167 of 99, in that they filed a mistake,
Okay, this case number
717 of 2004.
717 of 2000.
Zero.
2004. Okay, that you have encroached. But then earlier, that 2407 of 99 was already there. That was also
That-
encroachment.
Dismissed.
But they went in appeal against that order, no?
Again, that's it.
Then,
Then
but how did the court in 6991 pass an order when this appeal was there already?
my land is separate land. my friend. My land-
Okay, your land.
That is
So,
separate land.
okay, then,
The jurisdiction of that,
okay, then what happened? Then,
thereafter, they put an allegation and High Court ultimately, my lawyer also withdrew from the case. That irritable. Thereafter, High Court, decision maker of High Court passed an ex parte final order.
against you.
Against, not me, they, whatever the allegation submitted in the irritable court, they directed to restore the same land, which is in my land.
Acha, directed to restore the land to the writ petitioners in that writ appearance. Where order dated?
Order ticket is 2305 200 2005. 2312.
Acha, tell me, this WPC 6991 of 2003 disposed of by which order?
Not this was, this is directed, disposed of by 29 2000. 2006.
292003. So this, the writ court was not informed of the pendency of 69. But what is the connection between your land and their land? This that number 295,
Yes,
number 2.
different, separate land.
Whose land is this?
This is separate land.
Is it your land?
Yes, fine. That number 293 is my land. 295 is their land.
295 is it. So the question is whether there is overlapping of these two plots
Oh,
of land.
my God.
No. So that is the question it appears here. So then what happened? Now why
I
is
go
this
pass
court
this-
here?
Pass this order to restore a piece of land which is imaginary. That cannot be restored. This is not in existence. So that file is called writ petition. Writ appeal.
So what are you challenging here? What are you saying? You are against the order passed in the writ appeal.
No. Writ appeal, order, in that order, district administration, who is not finding that land as directed by the writ appeal court, they enforce my, trespass into my land, broken my boundary wall, house, and handed over the same, the restaurant for 9
Then?
Then I went to Supreme Court of, I filed a review petition. That was also
The review petition before the writ court, the appellate court, WA, division bench. Then that was dismissed.
that was
You went to the Supreme Court.
I went,
Then what did Supreme Court say?
why not this? Annexure 13. Annexure 13, my lord. 116 is page number and 118 is the operational order.
Okay, so it directed that the So it has directed that you should approach the civil court.
No, my lord, first, High Court directed restoration of writ petitioner disposed during the pendency of the writ appeal. And such disposition was exceeding the ambit of the order dated 2/9/2003 in WPC number 6991 of the 2003, filed by the petitioner without disclosing the pendency of the writ appeal. We find that the division bench of the High Court has not decided or expressed any opinion in regard of merit, but has merely relegated the parties to approach the civil court in accordance to law, subject to restoration. There is therefore no need to interfere with the said order, except to provide the following steps. Respondent number 1 to 3, to whom possession has restored on 25/1/2006, in pursuance of the order dated.
So then you, have you approached the civil court?
Yes.
What is the case number?
That is,
That 2011.
yes, 20 of.
So now, so then what remains right now? What is to be done? The 2011 has to be disposed of.
Yes.
So has it been disposed of?
No.
Then when is the contempt?
This is the contemporary.
Contempt against whom?
It's Deputy Commissioner in Supriya.
Why?
Then, because he has, with the, this is the order of the Honorable Division, order of the Division bench of the.
How, where is the, which order has he received?
Annexed to six, my lord.
Page?
'81 to 102. 101 is the operating part of
Just a minute, 81.
81.
81. No, this is the, where is the operative portion?
101, my lord.
101. Yes,
35 para, first part, my lord.
yes.
In the wake of the above, it is ordered that the respondent authority would forthwith restore the appellant's position in respect of the following land. Land measuring more or less 2 kata under part tag number 295. In PP number 2, it is there tag number, madam. Situated in Tinsukia North, Tinsukia town 2 ward 2 under Tinsukia Mauja, Tinsukia district, Assam, and the said plot of land is bounded as 10 feet wide existing road. In north, in the north, there is no road existing, my lord. South part of tag number
So
265.
where is the contempt? Then what happened after this order? What has happened?
After this order, DC did not find this land as directed by the retailer.
Where is that? He did not find. Where did you find?
So he has not demarcated the land. First step for identifying the land.
So if he has not demarcated, so where is the contempt? Supposing I tell you, go to the Brahmaputra, find that black boat and paint it white. Supposing you go to the Brahmaputra, you don't find the black boat. And you don't paint any boat white. What wrong have you committed? Similarly here, if the DC does not find the land, and accordingly, if you cannot find the land, you cannot demarcate it. So where is the contempt?
But he has admitted that he has complied the order. He has restored the position of the land.
But where
That
is
is in
it say? But okay, in that case, where is the document supporting your submission that the DC could not find the land? You have said the DC could not find the land. Where is that?
He has not measured the land. He has not.
Oh, that is your submission. Okay, sorry.
This is
It is not an admitted fact, that means.
This is submitted that.
Huh?
This is also submitted that.
Where is that? Where is
Yes,
that?
my lord. That is in,
You see, I do not know where the contempt lies. The contempt is basically when there is violation of a court order.
that is,
Now, where is the contempt? Are you here for are you counsel?
I'm for the petitioner number 12.
Or who, who's petition, he's petitioner number one,
Petitioner number one.
who's two and three?
Petitioner with his mother and brother.
So what is the case? Is there any contempt? Is there any contempt? What is the contempt?
They have misused the order of the Honorable High Court,
Where is the misuse?
submitted report on a annex charge.
You are making, a-
Seven, my lord.
you are making a mountain of a molehill, it is, huh?
71035.
Yes. Has restored position, that's all. Acha, so he has restored position, now you are saying that actually there is no land to restore and he has restored it. So that is your allegation against him.
Number second point is that without demarcation or measurement, nobody can identify land.
So that, those issues will be taken up in the civil court. You pursue that, you pursue your allegations in the civil court.
I filed the better put it to court, but
So what is, what is the suit now? What is the case in the civil suit? TS, TS, 20 of 2011.
20 of.
So what is the state? What is the
Item petition.
Huh?
Item petition. 398 of.
Mr. Counsel, is it in the evidence stage, framing of issue
no,
stage,
PW.
hearing stage? What?
PW.
PW evidence. So you wait for the decision. There's no contest.
That's not disclosed with petition and continuing delay from 2011 to now. It is 30%.
Now what can I do in a contempt? So you have made those, officers a party or what? Judicial officers a party or what? Huh? Oh, he has made the district. Oh, and I was taking a case so seriously.
The party, district court party, all of them are party.
Huh?
Actually, what happened was, if you are 6 of 170, there was a direction of the honorable court to dispose of those fruits within a period of 6 months. So they have not disposed the period of 6 months. That is why he is, that is only his part of the agreement.
Okay. That's your case. Where is that order?
It's from 160 to 170. It's the last. The 170 is of the
166 to
170. The lawsuit will find the title is pending in the court of the landed rules, but violated the dispute of February 6 from 28/2008. This is the what? This is the testifying point.
so this is that
Testifying point is separate.
that's all.
170. Sticking to the type there.
Okay, I give you two options. I give you one option. You withdraw. Then I dismiss. You can go to the division bench. But there is no appeal in against the dismissal. I'll tell you that much. There is no appeal against the dismissal of a contempt case, closure of a contempt. There is only an appeal when a punishment is awarded. Think carefully.
That, with equity.
Mr. Khan, this is 21. It is so thick, this thing, for such a issue.
If I can read about 1 bit 10,
I have heard you, then to understand whatever he has said, I have to again write everything.
1 bit 10,
Okay, you think carefully. Because you see, you see, the world is not as we want it to go sometimes. It's part of life. But just because it doesn't go like this in a straight line, it goes vera here and there. Doesn't mean that, you can file a contempt on that. And that, because contempt is a serious matter.
Nobody is obeying the order of this court. It in a simple order of, ridiculous order of, so I find that, that of the no order has been applied. Missed by, but that's our issue.
My wife also sometimes doesn't obey my order. What are you talking about?
Court's order not to be.
Ah.
One is.
Okay, right. Right, Mr. Joydeep Bhattacharya. Petitioner number 1 in person. And Mr. Bhattacharya, then counsel for the J or A?
Why?
No, you.
Say it's only written. It is now in the context, it is showing that I am 69%. And
For the respondent number, for the petition number 2 and 3. So, the other side is Mr. R.K.D. Chaudhary appears for. The point number 7, Mr. R. Chakrabarti for 8. A.K. Sudha for 9 and 10, and Mr.
H. Rahman.
H. Rahman for respondent number 1. The matter pertains to encroachment of land. While the respondents number 9, 10, and 11 are the owners of land covered by tag number 295. Correct. Sir, that is your land also.
My land is, 298.
That is what I'm saying. While the respondents number 9, 10, and 11 are the owners of land covered by tag number 295 PP number 2, the petitioner is the owner of land covered by tag number 293 PP number 116. The issue involves the genesis of the present contempt case is with regard to the allegation of encroachment made by the parties against each other, which resulted in the respondent number 9, 10, and 11 filing WPC 2407/1999, which was dismissed. The dismissal of WPC 2407/1999 was challenged by way of writ appeal number 167/1999 and a consequential missed case number 717/2004. The petitioner, on the other hand, filed WPC number 6991/2000 against the respondents number 9, 10, and 11, praying for protection of his land, life and liberty. The petitioner in person submits that in terms of the order passed in WPC, in terms of the order dated 2/9/2003, passed in WPC number 6991/2003, the deputy commissioner was directed to demarcate land covered by 293 PP number 1136. The petitioner in person submits that after demarcation of his land, the petitioner has made a boundary wall over it. However, the division bench of this court when is that division bench order? In Page? The division bench. In its order dated, in its judgment dated 23/12/2005, in WA 167 of 1999. Pass the following direction in para 35 and 36. That's all. Para 35. That's all. Page 101, 102. Okay. Then where is the Supreme Court judgment? Being aggrieved by the judgment passed, judgment dated 23/12/2005, passed in WA 167/99. The petitioner filed an SLP bracket C number 2457-2458 of 2009 before the Honorable Supreme. The Supreme Court disposed of the SLP as follows. Para 4, huh? Para 4, as follows in para 4, page 117, 118. Huh? Click up. And where is that impugned 111? That visit expedition visit a period of huh? Huh?
117.
How did this petition come into being? This 166-7011 of 2016?
Directed to a particular period. Clearly, this was not
It was not being complied with. He filed the
Uh,
petition.
by the civil court. So he
Okay,
can find.
okay, thank you. A review petition was thereafter filed by the petitioner in person against the order dated 25/10/2006. Passed in the SLPC number 2457-2458-2009. Which was dismissed. Subsequent to the above, the petitioner filed WPC filed title suit number 20 of 2011 before the court of the Municip number 1. 1650. The same was subsequently renumbered as title suit number 1 of 17 bracket Margarita. And title suit number 9 of 17. What is 9 of 17?
It was, transfer to civil judge, senior division.
And title and then and no, wait, renumbered as title suit number 1 of 17 Margarita, and thereafter again renumbered as title suit number 9 of 17 when it was transferred to the court of the civil judge senior division of Assisi. To cut a long story short, the case has been again renumbered to its original number of CS 20 of 2011 and is pending before the civil judge at senior division. As CS 20 of 2011 had not been disposed of in terms of and was not being disposed of, the petitioner in person filed WPC number 7011/2006. WPC 7011/2016 was disposed of by order dated 13/8/2018 as follows. Page 170. It will be in red, okay? Here. Red, page 170. The petitioner has filed the present contempt petition against the respondents, which include the following persons, 1 to 11, page 4 and 5. On the ground that the title suit was to be disposed of, preferably within a period of 6 months from 20/08/2018, and the same has not been done till date. Next paragraph. The petitioner's grievance against the Deputy Commissioner Tinsukia is that though the division bench of this court in WA number 167 of 99 had directed the Deputy Commissioner to restore certain land to the respondents number 9, 10, and 11. No land being available, the PC could not have restored land which he could not find. No, which was not in existence. Land which was not in existence. So further, the DC could not have made demarcation on a non-existent land. I think that covers everything.
Yes, applicant said he has supplied the rest of the land.
Here, the petitioner in person that subject that the statement made by the TC that he has complied with the orders of the Indian bench. CWA number 16799. Is that incorrect? And he has restored it to 9, 10, 11, not to you. Is it correct? And accordingly, should be punished for contempt. This is the matter on when Monday. This is the matter on Monday. Huh? Monday. By which date the petitioner in person shall consider whether to press the contempt petition or not. Take a decision. I am very clear what I'm going to do. Like, I think that's it. We'll give him time to consider. Have I missed out anything? Any facts? No, no.
Madam, I may be accommodated some more time.
Or item number?
I think 36, madam.
Please.
You
You have not filed the application.
some more time may be
Okay,
accommodated.
Mr.
And came more, madam.
Learned counsel for the petition is granted for the 3 week time to make appropriate application for impeachment.
The office notes indicate that neither the AD card nor the answer provision is received.
What to do? Taxi service or what? What to do?
Taxi service only possible at the station in Bombay.
Oh, Bombay.
What to what more?
The fracture server.
It seems it is not coming there.
21/5. Okay, the notice issued on 31/10/2022. Fracture. Right. In terms of the office note dated 21/5/2024. There has been no return of AD card or unserved notice from the sole response. On the notice issued to him on 31/10/2020. The petitioner is directly take fresh steps for service of process upon the response by registered post office. Afresh. It shall within 3 days. This is the matter after. There is no application for impeachment not required. What is your instruction that it has been complied with or what?
They stated they executed the order by evicting the enforcer.
By making them,
By evicting the enforcer.
then what do you mean?
Look, only thing that when the enforcers are there, enforcers have varying position at the time. There needs a permanent position at the point from the deputy commissioner to that area. That if you are record, I have nothing to say. Because they have complied the order.
Let them file the affidavit of the file. When will you file?
Within 10 days.
Why within 10 days? Within a week? Okay, Miss
And then,
N.A. Sharma appearing for the respondent submit that the order has been complied with and the enclosures have been evicted. Correct? He submits that he needs a week's time to file affidavit. This is the matter. Keep it.
make it usual order.
Oh, where's your application?
Please then may be granted. While application for implement of a new income.
Lordship, one and two both are,
Or to both are,
one is also retired.
one is retired.
Yes, no.
Okay, Miss A. Loda, Planet Council, for the Planet Council topic that the respondent number one has retired. And the respondent number two has been transferred up. Mr.
Arya.
R. A. Ahmed appearing for the petitioner submit that he will file appropriate application for impeachment of the present incumbent. Accordingly, the matter is adjourned for 2 weeks.
Applies to